अच्छा अच्छा अच्छा
Your Lordship, may I have your Lordship's kind leave to file one GA with short service arising out of EC. This EC is to appear tomorrow, Your Lordship. I'm preferring one GA application. This is the matter about Dipankar Banerjee. Your Lordship heard this matter several times. I'm being led by Miss Noel
This
Banerjee.
GA application for?
GA application is for dismissal of the main EC, Your Lordship. It's the three analogous matters appearing together. Your Lordship has specially fixed it tomorrow for hearing. If Your Lordship will kindly grant the leave.
Let it come up tomorrow.
With short service, Your Lordship.
Affidavit of-
Grateful, Your Lordship.
My lord, may I be permitted to mention, my lord, upon notice to my learned friend, my lord, item numbers 38 and 39 of the monthly list. Oh, today's list, I'm sorry.
Lordship, one. It
38.
38 and 39, my lord. One of the applications is my application, and the other application is my learned friend's application. My lord, we're in some difficulty this half of the vacation now. My lord, praying that it be fixed 1 week after court reopens, or 2 weeks, my lord.
Lordship, yes, Lordship. Kindly fix after
Don't
the
need-
vacation, Lordship.
Very well. No difficulty.
অঞ্জনবাবু ওটা কি অর্ডার করে দেবো হ্যাঁ on the prayer of the learned advocates for the respective parties 38 and 39 huh? Mr. Medora 38 and 39
38 and 39, my lord. Pasani matters.
release this matter 2 weeks after the ancient puja after 2 weeks
18th November, my lord. Most grateful.
Grateful. Thank you.
after 2 weeks করে দিলে 18 তেই আছে আর কোনো মেনশন নেই তো
Regular range for judgment, item number 1.
in 5 and 6
5 and 10. 5 and 6. Oh, 5 and 6.
5 and 6 all the 4 trustees are discharged from functioning as trustees. Mr. Aniruddha Mitro and Mr. Choyan Gupta are appointed as joint administrator. They will operate the accounts and collection of rents and whatever the administration requires. They will submit regular audited accounts on monthly basis before the registrar original site. They will also take steps to hold election for formation of new board within last week of November 2024. By 5th October 2024, within 10:30, the discharged trustees shall hand over the charge of the trust estate to the joint administrator. So far as prayer for revocation of deed of conveyance is concerned, that is dismissed. However, it is left to the new board of trustees or the petitioner. Petitioner is a Sebayat?
Sebayat.
Or the petitioner to file regular suit for revocation of the sale. GA 5 of 2022 is allowed to the extent of appointment of joint administrator. So far as GA 6 is concerned, prayer A, this liberty has been dismissed, but however, it is left to the new board, if so chooses, to file a fresh application. That liberty is given to the new board. As regards continuation of the as trustees, that is also dismissed since they have been discharged from their functions. And prayer C of GA6, it was allowed, but prayer C was to, during the pendency of the application, they will continue to, that was allowed, but that stands vacated after dismissal of the application. Chamber party.
Judgment would be uploaded
By today, it will be uploaded. Oh, 5 টা disposed of হলো না। 5 টা it will be listed on Mr. Boral. Your application is kept pending. 6 is disposed of. 5 is kept pending for submission report by the joint administrators. Yes,
By 30th of November.
but last week of November 2024, the administrators shall hold the election.
And they would, other appointed trustees by this court would discharge their office by
5th of October.
5th of October.
They will hand over the charge. Yes. Application দেখুন কবে আসছে, আমি ডেটটা দিয়ে আমাকে 2nd না 5th December আসছে মনে হচ্ছে। 5th December.
Commercial bench, item number 1.
I am appearing on behalf of the decree holder, Your Lordship. Your Lordship, on the last occasion, was pleased to grant an injunction restraining the decree judgment debtors from withdrawing any sums of money of 40 lakhs in the bank accounts. We have tried to serve you, the judgment debtors, Your Lordship. May I file the affidavit of service? It came back with the endorsement left. But Your Lordship kindly considers this is nothing but a ploy to avoid service, because on several occasions during the hearing of the suit also this has happened. And in fact, thereafter,
Suit was disposed of ex parte.
Your Lordship, the suit was not disposed of ex parte. Your Lordship, they contested the application and thereafter it was held in our favor, Your Lordship. And Your Lordship, during the hearing of such application, Your Lordship, the defendant partnership had written a letter to their advocate on record, which was produced before the court. Your Lordship kindly sees, even in that letterhead, the address is the same. And this letter is of December 23. Even in during the hearing of the applications in the suit, in which the order was passed, on multiple occasions they did not appear. Until the point of time the bank account was attached.
Give another notice.
Your Lordship, that letter at the top.
Where is the decree?
Decree is at with the tabular statement, Your Lordship.
And your affidavit of service to them?
Your Lordship kindly takes a look at pages 6 and 8. Your Lordships will find the endorsement left. Pages 6 and 8, Your Lordship.
Rajit Enterprise. Has the office been changed?
Your Lordship, no intimation to us. And Your Lordship, I am of the firm belief that it is still there. They are only avoiding service because kindly sees the letterhead which the defendant partnership issued, Your Lordship, which I just handed up to Your Lordship. Even in that letterhead, that is the same address. And Your Lordship, we have information that they are still present over there.
You give another notice.
Your Lordship kindly gives us also leave, serve the notice along with the judgment debtors Also to the advocate on record whose name is appearing on that letter, your lordship, of the which I just handed up to your lordship in the bundle.
যে appear করেছিল।
হ্যাঁ, সেটাই তো। Who
Letter, this letter?
your lordship, I just handed up a bunch.
আবার দাও আমাকে, আমাকে
Oh,
That
ঠিক
letter,
কথা।
your lordship, the advocate's name is appearing, and such advocate was appearing on behalf of the defendants in the suit also, at the time of the hearing of the application.
No, is there any requirement for a fresh representations to be made by the learned advocate so far as execution case is concerned? No.
No, your lordship. They need to just file a wakalatnama, that's all. But kindly allow us to serve upon on both of them once.
Mr. Affidavit of service filed on behalf of the decree holder is taken on record. Mr. Oyon Dotto, learned advocate for the decree holder, submits that pursuant to order of this court, notice has been sent to the judgment debtor. However, such notice has returned with a postal endorsement left, inverted comma, left. He submits that the judgment debtor is still carrying on its business from the address mentioned in the decree. However, intentionally the service has been avoided by the judgment debtor. He seeks to serve afresh upon the judgment debtor as well as advocate on record for the judgment debtor.
Who appeared in the suit, your lordship.
Who advocate on record for the judgment debtor defendant who represented him. Oh, it, huh? He made it in the, what was the suit number? In
Your lordship, CS 154 of 2022.
in CS 154 of 2022. In view of such submissions, let such notice be served upon the judgment debtor as well as advocate on record for the defendant in the suit being CS number token put and file affidavit of service on the returnable date. Release this matter third week of the year. After 3 weeks, 19th November. After 3 weeks, after Puja vacation. You take this way.
Grateful, your lordship.
Last week's keeping it on the 19th of November.
19th, that is coming after 3 weeks, 19th.
3 weeks will be 26.
26th.
Item number 2,
Well, this is my execution application, your lordship. Execution from a decree dated 10th April 2024 passed by this honorable court, my lord. And it will find the decree at page 16 of the execution application, my lord. Total amount claimed is 1,15,54,232, my lord. Will find that at column 7 of the tabular statement, my lord. My lord, the part of the decree has been complied with, your lordship, by the bank. I have pleaded that, my lord, in para 12 at page 7, your lordship.
Para 7.
Para 12 at page 7, my lord, I have pleaded that a part of the decree has been complied with. Lordship will find it at para 12.
This is ex parte decree.
Yes, your
Party.
ex parte decree, my lord.
Ex parte decree.
I have also annexed the undefended order, your lordship, where the suit was converted to the undefended list, my lord. My lord will find that order at page 14 of the
that's
execution
not
application, my lord.
Page
14, my lord.
12. No, you are referring to page 12.
Partial compliance. My lord, there were two entities against whom I had sought the order. My lord, the state of Madhya Pradesh and the bank, your lordship. The bank had complied with the order, my lord. Will find that at para 12 at page 7, your lordship.
Okay.
And I'm seeking orders against the defendant number 2, my lord, in accordance
Both
with
are jointly liable
both
to.
are jointly liable, my lord.
Decree is at page.
But the decree, my lord, will find it at page 16.
State of Madhya Pradesh Single Forests.
That will kindly come, my lord, at page 19, your lordship, the last portion. But fairly at the center, your lordship, the defendant number 2, state of Madhya Pradesh. My lord has found it. Defendant number 2, state of Madhya Pradesh, hereinafter referred to as the said defendant, do pay the plaintiff Kalpataru Agro Enterprise Private Limited a sum of rupees 28,33,356 with interest thereon at the rate 10% per annum for 24th day of November in the year 1998, being the date of institution of the suit till the payment of the aforesaid amount of 28,33,356. At page 20 as refund of money, and it is further ordered and decreed that the said defendant number 2 do also pay to the said plaintiff a sum of rupees 13,99,950 on account of loss of profit, and permanent injunction is hereby granted to the said plaintiff restraining the defendant number 2 from invoking or giving any effect to the bank guarantee bearing number such and such, such and such, and such and such, all 25th day of October in the year 1997, and the same is further ordered and decreed accordingly, and that the said defendant number 1, State Bank of India, shall cancel and deliver the said bank guarantee to the plaintiff, and the same is further ordered and decreed accordingly, and in case the decree is not satisfied within a period of 3 months from the date of drawing of the same, the plaintiff shall be at liberty to put the same in execution, and the same is further ordered accordingly, and the suit being CS Com number 21 of 2020 is disposed of along with pending applications. Now, Malad, I want to bring to your notice that the bank has already cancelled and delivered the bank guarantees. Bank has complied. I've pleaded that in para 12, Malad. And Malad will kindly come to page 24. I have communicated to the bank, State Bank.
Yes.
And Malad will kindly come to page 8 once of my application. Malad, the computation is given, Your Lordship.
Okay. Yes. Next.
Malad, next, Malad will kindly come to page 37 once. My lord, on 2nd August 2024, we have communicated to the defendant number 2. Your lordship, the secretary, Ministry of Forest, we have communicated the order. And the left hand side, there is a seal, my lord, they have received it. My lord, I am seeking orders in terms of prayers B, C, and D of the tabular statement, my lord. And my lord, I have also disclosed the bank account at page 10, para 19, my lord.
Which bank account?
My lord, the bank account of the defendant number 2, your lordship.
There has to be some specific account.
Yes, your lordship.
Where
My lord,
is
will
that?
kindly come to para 19 at page 10. My lord, I have disclosed the bank account.
So this is a department of the state of Madhya Pradesh.
State of
Government.
Madhya Pradesh.
What is this department?
It is the forest department, your lordship. My lord, will kindly come to the cause title once at page 2, your lordship. The judgment data number 2. State of Madhya Pradesh, through the secretary, Ministry of Forest, its officer.
What is the function of this Ministry of Forests in this particular suit? What was the grievance of the plaintiff against defendant number 2?
That have been led by Mr. Sengupta, your lordship.
Ah,
Lordship, what happened, Your Lordship? We actually floated the Ministry of the State of West Madhya Pradesh floated a tender for Your Lordship the supply of certain bamboos. Now, Your Lordship, we applied there. Now we got the tender, but at the time of delivery of the goods, we found, Your Lordship, that there are certain bamboos there was a termite. So there are certain lots which we could not lift it. So that's why, Your Lordship, the money which we have paid, that's the, Your Lordship, the refund of money we have got, and we suffered certain damages, and so that's why, Your Lordship, the damages we have received.
Asha.
I'm grateful.
This is an application for execution of decree dated 10th April 2024. Mr. Subhasis Sengupta, learned advocate for the decree holder, submits that despite passing of the decree, the award has not been complied with by defendant number 2. The decree holder, as per the decree passed by this honorable court, is entitled to a sum of rupees 1,15,54,232. The award passed was duly communicated to the judgment daters, including judgment dater number 2. He also indicates that the direction passed upon judgment dater number 1, State Bank of India, has been duly complied. And the bank guarantees have been cancelled. And all the bank guarantees, as directed in the order, has been cancelled. He seeks for orders in terms of prayer B of the tabular statement. By judgment dated 10th April 2024, following order was passed. 32. এখানে সেট আউট করবে না, এই 32. Next line, accordingly, decree was drawn up. It is contended that such order of this court was duly communicated to the judgment dater number 2. Where is that letter you have just indicated?
Page 34, Your Lordship.
The letter dated
37, my lord. I stand corrected.
2nd August 2024 at page 37 of the application shows that the order has been duly communicated to judgment dater number 2. Despite such communication, the amount as directed by this court has not been paid. Accordingly, the judgment dater number 2 and its officers, employees, men and agents, servants and assigns are restrained from withdrawing money from the bank account being number 185705004699 at ICICI Bank, Balaghat branch, Gondia Road, Balaghat, Madhya Pradesh, pin code 481001. Without keeping aside a sum of rupees 1,15,54232. वर्ड से लिखे थे मैंने 1,15,54,232 only. Until further orders. Let there be order in terms of prayer B of the tabular statement. Issue notice upon judgment data number 2. Release this matter 3 weeks after the entry puja vacation. Yes.
Let us kept it 3 weeks after
After
the
3 weeks, notice be issued and they prayer
I'm
B is allowed.
so grateful.
Next. আমাকে না ওই চয়ন গুপ্ত আর অনির্বাণ মিত্র কোন ভারে বসে তার ডিটেলসটা ফোন নাম্বারটা ওকে দিয়ে রিপোর্ট করে
Item number 3.
But happy for the judgment date. The last occasion
They are paid. Payment has been
paid initial amount of rupees 10 lakhs, my lord, and the rest of the amount they propose to pay off in equal monthly installments by 31st of March 2025. My lord, the thing we have agreed not to charge further interest on the amount, but whatever has been charged, whatever has been claimed as per the tabular statement, they have agreed to pay. My lord, the total amount which is due as per the tabular
no,
statement.
you have received 10 lakhs of rupees. When will the next payment be made?
Within
From
October,
this
with effect from October.
with effect from October.
No, 10 lakhs plus
10
Yeah.
lakhs,
10
10 lakhs
lakhs is the down payment.
the first payment that we have made.
And
Apart from that, the rest amount is around 43, 46 lakhs something. And that will be
61.
paid in 6 equal monthly installments starting from this month,
okay.
October.
My lord, my submission is let the judgment data representative is present. My lord. Let him give an undertaking before the court as regards the payment, and the execution application be adjourned sanitary with the liberty to initiate the same again.
The degree holder, judgment debtors directed is present before your lordship. And we have given them letter also.
Letter
If in spite of that, if he seeks,
that is
record
an
going.
undertaking from the letter. In any case, he is examined in part, and his examination is still to be completed.
it may be postponed, my lord.
No, I'm not asking for the examination at the moment.
But undertaking need. Ask him that 10 lakhs amount has been paid and next he undertakes to
You have paid.
yes.
So,
Address Sanjeev Kumar Visual.
Yes.
Mr. Biswal,
Yes, sir.
you have agreed to pay the amount of rupees 53,61,505 as claimed in the tabular statement,
Yes, sir.
out of which you have paid rupees 10 lakhs.
Right, sir.
ঠিক আছে। I'm sir, my lord, I'm asking him directly you propose to pay. How do you propose to pay the balance?
Balance amount will be paid within 6 months. The balance amount will be paid within 6 months. Within 6 months on equal installment.
That commencing from
First
October,
October, and it will be
completed by
31st March 2025.
Okay. That's all. Ashwin. Mr. Sanjeev Biswal, Managing Director of Ruby Air Freight Limited, is present in court. Both the learned advocates for the decree holder as well as judgment debtor submits that an amount of rupees 10 lakhs has already been paid to the decree holder by the judgment debtor, and the rest amount of rupees 53. What is the amount? 53?
43.
43? Amount of
43,61,505.
43,61,505 will be paid by the judgment debtor in 6 equal monthly installments commencing from October 2024. Next slide. The judgment debtor, Sanjeev Kumar Biswal, gives undertaking that the balance amount of rupees 43,65,505 will be paid by him within 6 months in equal monthly installments commencing from October 2024 till 31st March 2025. Making it out of list for the time being.
Out of list with liberty to mention, my lord.
Yes. Learned advocates for the respective parties seeks for making the matter go out of list with liberty to mention. Or you can let the matter go out of list with liberty to mention.
The personal appearance may be dispensed with. Record
দেখি কি বলছে?
The personal
What is the monthly installment is to be paid within which date?
28th of each month.
28th.
28th. The first installment will be paid by 28th of October. Thereafter on 28th November.
28th of each month.
But the personal appearance may be dispensed with.
The personal appearance of the judgment debtor is dispensed with
Grateful.
for the time being. ওখানে undertaking টাও ডেটটা বলে দেবে 28th of each month.
Regular bench item number 3.
Lordship, may I have your lordship's leave to mention one matter, your lordship?
Next, item number 3.
I appeal for the plaintiff and today is for framing of issues. May I hand up the suggested issues?
Who is for the defendant?
On the last day, Mr. Joyok Gupta appeared.
What is this GA2 of 2023?
GA2 is for framing of issues and appointment of a commissioner. But issues may be framed for
appointment commissioner filed by you?
Yes, filed by me. If the issues are framed, Lordship may direct the Commissioner to be appointed.
This matter is appearing under to be mentioned.
To be mentioned.
It was mentioned by.
Yes, my lord, my.
You have given a notice to the other side.
I hope so, but my lord, I'm not sure.
Acha. Keep on.
But keeps it tomorrow, my lord. I'll serve a notice. We'll come back tomorrow.
This matter is appearing under the heading to be mentioned. It is informed by the court officer that GA2 of 2023, which is appearing in the list. Sorry, Act of Constitution, the cause papers of GA2 of 2023, which is appearing in the list.
It is informed.
It is informed by the court officers that the cause papers of GA2 of 2023, which is appearing in the list, has not been sent by the department. Department concerned is directed to place GA2 of 2023 on the returnable date. Always. Under the place this matter on 6th November.
Great.
New chamber application item number 4.
In this matter, I am for the petitioner. It's an application for substitution of defendant number 1. Right. This is an application for substitution of defendant number 1. It's a partition suit, my lord. Defendant number 1 already expired, my lord, and your lordship's order was, my lord. The lordship's order was, my lord, 16 July 2024. The date of the defendant number 1 has already been recorded, my lord. In view of the application, my lord, order 22, rule 4, my lord, sub rule 4. We took out an application for recording the date of the defendant number 1 and also to proceed with the suit since we don't have the knowledge of the legal layers of the defendant number 1. My lord. Your lordship was pleased to direct us to record the date of the defendant number 1 and to come with a substitution application. My lord. In view of your lordship's order, my lord, we came up with this application, my lord. It was well within time, my lord, and we have served upon all the respondents, my lord. 2 years, my lord. Harvinder Kaur and Amarjit Kaur. 1A and 1B, my lord. Amended plaint, my lord, appearing at page 14 of the application, my lord.
Hello?
Who are the contesting defendants? You have served upon contesting defendants?
My lord.
Where is the service?
If you give the service, it master summons, my lord. My lord, Daljit Singh, my lord, defendant number 4A, appearing, my lord, Dev Kumar Chandra, my lord, it is served, my lord. And on all other defendants, my lord, we have served through speed post, my lord. 1A and 1B, the substituted, my lord, service, my lord, that is already, they have received, my lord, that is track report is with the affidavit of service, my lord.
1A and 1B.
1A and 1B, my lord.
Where are the track reports of others?
My lord, track report we could not get, my lord, because 4 days notice is required, my lord. Otherwise,
Get the track report.
track,
Then move.
track report is with
There are 6 defendants.
my lord, 6 defendants. One is pro forma respondent, my lord. In spite of that, we have served. 5, my lord, 5 defendants, my lord.
5.
5, my lord. One is pro forma defendant, my lord. And others, my lord.
Nirmal Singh is defendant number?
Nirmal Singh is my lord, defendant number, my lord.
3.
3, my lord.
Nirmal. Again. Saraswati Devi. Defendant number 5.
Is pro forma. Saraswati Devi is pro forma respondent.
Pro forma. Harvinder Singh. 2. You have given track report of which defendants?
1A and 1B, my lord.
Name.
The name substituted defendant. And 4A, my lord, Daljit Singh is served through advocate, my lord.
Received. Daljit received. Paramjit Kaur.
Paramjit Kaur served, my lord, but track report is not with the affidavit of service, my lord.
And a complete tracking report. Mr. Swenson, an advocate for the petitioner, seeks accommodation to file. Complete file affidavit of service. প্রথমে উপরে দিয়ে দিন affidavit of service filed on behalf of the petitioner is taken on record. Mr. Swenson, an advocate for the petitioner, seeks accommodation to file. Further affidavit of service annexing the track reports in respect of the other defendants. This matter 1 week after the event.
Item number 5.
I am for the judgment debtor. In the execution application, I am for the general. On the last occasion, my lord, and pleased to record, it was a joint submission on behalf of the parties that the matter is in the verge of settlement. And my lord, they also, my lord, being the petitioner, my lord, accepted the position, but the settlement, even lordship was pleased to record in my lord's made order that the last order, my lord, that the settlement is almost in the verge of completion, my lord. My lord, is expected to be completed and the needful document may come out.
What is the position now?
My lord, it is my learned friend is also settlement is expected to come out in after the puja
vacation. The advocates for the decree holder as well as judgment debtor submits that the settlement judgment debtor submits that you are for decree holder.
Yes, my lord, I am for the decree holder.
Decree holder submits that the settlement is on the verge of completion.
Your lordship, just my lord, one just
and they submit for fixing the matter after the vacation. This matter 2 weeks
after.
We
expected to come.
Just one indulgence, my lord. Last order also, my lord, they had come and said that the decree is on the verge of settlement today also.
You don't
it is not
the position.
No, I accept.
Then kindly do the matter. Because I have the instruction.
I'm not saying we are not agreeing, but I'm saying
my lord,
2 weeks after the, 2 weeks after the vacation and
Yes.
Mr. Roy Chaudhary will no record করবেন না. Mr. Roy Chaudhary, you take the endeavor to settle the matter and come up.
Well, at least it may be said at least.
Your lordship kindly sees the series of orders. It's only being settled. The money is not coming.
Completion. Yes, 2 weeks after the vacation.
Well, this issue is at least expected to be settled. At least there is no receiver in this matter.
Extremely grateful. Lord.
Yes.
Item number 6.
Lordship, this is my application. My lord, this probate application was filed in regard to the will of the deceased.
Yes.
At the time of the death, the deceased was residing within the jurisdiction of the city civil court, and the immovable property is also situated within the jurisdiction of the city civil court. So, my lord, in view of the amendment in the City Civil Courts Act, my lord, section 300 goes. So, my lord,
Is it the appropriate order?
the appropriate order may be passed so that
Huh? What is your prayer A?
they are prayer A, my lord, there is some typographical error, my lord. But what
Withdraw
I am
this
thinking
application.
is, my lord, transfer of this application to the City Civil Court before the
Withdraw this application, file fresh application.
my lord, the stamp duty has already been paid and the originals are already been filed before the High Court.
What do you want in this application? The prayer is not proper.
My lord, with regard to the prayer B, necessary leave may be granted to me so that the original and the stamp duty may be returned to the applicant.
Where have you written? Where is the prayer?
My lord, prayer B at page 6. Necessary leave be granted to the
দেখো
petitioner.
মাস্টার সামান্সে কোথাও নেই এটা মাস্টার সামান্সে there is no such prayer.
Prayer is there in the
চাইছি আমি বুঝতে পারছি না. What do you want?
My lord, this probate application has to be decided by the City Civil Court.
So,
My lord, this has been wrongly filed before this High Court.
so withdraw this. Withdraw the application.
Section 14, my lord, the provision says that it has to be returned to the present tenant so as to file before the necessary court or the appropriate court.
কি ডিফিকাল্টিটা একটু দেখুন তো স্ট্যাম্প ডিউটিটা রিটার্ন করতে হবে তো you need those stamp duties to be returned to you.
And the original will and the death certificate.
So what is there? Where have you prayed for that?
My lord, should I come back with another application?
That is what I'm saying. You withdraw this application, file afresh with proper prayers. Huh? Mr. Swensol, an advocate appearing for the petitioner, seeks to withdraw the application with liberty to file afresh due to some technical defects. In view of such submissions, the application being GA1 of 2024 is dismissed as withdrawn with liberty to file afresh.
Item number 7.
This is my application, my lord, for amendment of the probate petition pursuant to a lordship's order, last order dated 19th of July 2024, which I have annexed as Annexure A at page number 4. If a lordship kindly looks at, initially when the probate petition was filed, the prayer for issuance of citation was not there. Accordingly, my lord, this application has been made, and because one of the properties, immobile properties, is situated in Mumbai, so the district has to be specified, which was entered, I'm told, by hand in the affidavit of assets. And also, my lord, on 4th of July, we have a receipt also with regard to that. And my lord, the undertaking is given in this application to comply with the provision of 283(1)(c) of the Indian Succession Act. Pursuant to that, my lord, the prayers need to be amended as shown in red ink. At page number 6 of the application.
Six
at running page 12. The prayers have been duly amended, my lord, in terms of your lordship's last direction.
Respect of your বলেছিলাম তবে the rule of the limit the ability to incorporate To incorporate.
There are two immobile properties. One is in Mumbai and the other one is in Kolkata, my lord, at Baliganj. So, general citation in respect thereof and also publication of the same in the newspapers.
The amendment has been carried out.
No, my lord, this is the application for carrying out the necessary amendments.
The
Yes, in
amendment there was leave was granted
yes, in the
to
affidavit. of
incorporate district Mumbai in the affidavit of
Yes,
assets.
that
Now
is
you
done.
faced problem because the department was not allowing to incorporate that.
Yes, that
Have
has
you
been
taken
done.
out an application or the amendment has been carried out?
Amendment has been carried out, I'm told, by hand on 4th of July, pursuant to the leave. That's the received copy, my lord, which I have handed over.
Have
to
you
Ravi.
mentioned in this application that such amendment was carried out?
No, that is not
That is not-
specified in this application, my lord.
এটা PLA টা আনতে বলেছিলাম PLA
Last,
application
my lord, this application
আচ্ছা,
was not there before your lord.
এটা PLA application টা আনতে বলেছিলাম যে অ্যামেন্ডমেন্টটাকে
My
কালকে
lord, we have a certified copy of the application also where the by hand correction is indicated.
ওইটা আছে
This is a certified copy.
give a copy of this in the record. Huh? Give
Yes,
a
your
photocopy of this. Ashun. This is an application for amendment of the prayer in PLA number 376 of 2023. Miss Suchismita Ghosh, learned advocate, appearing for the petitioner, submits that pursuant to order dated 21st May 2024, amendment to the affidavit of assets have been carried out, incorporating District Mumbai Maharashtra in Schedule A of the affidavit. The present application has been filed for issuance of general citation for amending for incorporating prayer for issuance of general citation in respect of immovable freehold property lying and situated at Mumbai, as well as the property lying and situated at Baliganj, and for publication of gist of general citation in English Daily. She files photocopy of the certified copy of the application showing incorporation of the words district and Maharashtra, district and words go with the words district inverted comma and Maharashtra in Schedule A of the application. This is part of application affidavit, no? Schedule A of affidavit of assets,
Affidavit of assets.
which is taken on record. In view of submissions made on behalf of the petitioner and the averments made in the application, let there be order in terms of prayer A, B, A to C করে দিন। A to C. A to C. Of the master summons. The application being GA1 of 2024 stands disposed of. Give a copy of.
Prayer B is concerned. It has been indicated that within 4 weeks from the date of passing of the order, because we are faced with the
Department is
vacation
এটা করে দিন। Prayer A to C.
to be carried out 2 weeks post vacation, if may be directed.
The department is directed to carry out the amendments within 3 weeks of reopening after ensuing puja vacation.
And my lord, so far as recording of certified copy is concerned, that's the original certified copy, not a photocopy which I had handed over to your lordship. I undertake to file a copy of the photocopy of the certified copy in course of today, which may be kept on record.
That is what is recorded. Photocopy of the certified copy is filed, which is taken on record.
This is the original. This is the original. I'll
Photocopy of the certified copy.
photocopy of
That is what you are filing.
that which I'll file. Yes, which I'll file in course of today.
Photocopy of the certified copy is taken on record. What does that mean?
Yes, it
Are
will
you
be
filing the certified copy?
This is the original which I had handed over.
You
but
make
I
the
will not
photocopy of the origin.
followed my lord.
Yes.
Yes.
দিয়ে দিন।
May I take back the
Yes.
চিঠি ছিল।
Item number 8.
Yes, sir. Just that matter in which I made submissions before your lordship one day, praying for release of the suit on the ground that the commercial
Two suits are there. One is eviction, another is for
declaration that I'm
declaration.
attended. My lord, on that, though there are many observations by various coordinate benches that the suits should be heard together, my learned friends insisted that a petition should be made. I've taken out a petition. Now, my lord, they say they want to file an affidavit. I can't stand in the way, so by consent, subject to my lord's pleasure, let
So
affidavit
this is an
directions be
application
given.
for.
But kindly, my lord, make it as expeditious as possible after
This
the
is an
vacation.
Well, Lord, will give me till
application for
Would my lord kindly
releasing
excuse
the
me, my lord?
instant suit
I'm very sorry. May I ask for your lordship's excuse, my lord? One matter, I'm being summoned in the
Yes,
next.
yes. Instant suit to enable the plaintiff petitioner to approach the Honorable Chief Justice for assignment of the instant suit before the judge who has determination to hear the defendant suit instituted in the year 2011, being CS number 189 of 2011. Mr. Who is for defendant?
Lord, I appear, my lord.
You are for
agree.
Mr. Dattu is for?
Well, I am for the plaintiff, I am assisting Mr. Bose, my lord.
Okay. Mr. Shonok Mukhopadhyay, learned advocate for respondent defendants seeks to file affidavit in opposition. Let such affidavit in opposition be filed
My lord, 1 week
within-
after vacation, my lord, full
within
kindly.
1 week after the ensuing puja vacation. A reply thereto be filed within a week thereafter.
Grateful, man.
Matter 2 weeks after the ensuing puja vacation.
Grateful, man. I'm really grateful, man.
My lord,
Any 2 weeks after the vacation.
Really grateful, man.
Next.
Item number 9.
The application. But in this, commissioner has been appointed to record the evidence on commission. And that has been appointed, but what happened at the commission, we found the judge's brief of document has not yet been filed. So Lordship has given me a liberty.
The issue has also not been.
No, issue has been framed. Lordship, remember that noticing the issue has been framed. I'm sorry, I made a wrong submission on the last occasion.
Okay.
Issue has been framed on 20th of March by a coordinate bench, my lord. So for the my lord's last order is concerned, my lords, the judge's brief we have filed in the department.
Okay.
And we have offered the inspection also. So my lord, we can continue with the commission.
From our side, my lord, we are from the defendant, my lord. We need some time to file the documents because my lord, the advocate.
That's not a problem, my lord. It's my witness because my witness will prove my documents. I need not prove his documents. Now I can start with the work of commission. If he files in the meantime, he can do it always. I cannot stand in the way of the defendant filing judge because this is going on for last 1 year.
Okay.
These applications and other things.
Who is the commissioner?
My lord, order is page 12. Page 12 of my lord's application is the order. Yes, he can file, definitely. Yes. Mr. Shonendu goes in the next page, my lord, into page 13. Issue frame hai guys. আমি আগের দিন ভুল বলেছি
13 years.
So this on the first day we met this problem. This is recorded in the commissioner's minutes of at page 14. The problem with the commissioner faced.
So 9 is for this GA9 is filed with
this,
which
this is the GA9, which is my lord's is hearing. This is the prayers are my lord will. Once the judge's brief is filed on behalf of the plaintiff, now we can. Now the second prayer of mine is that if my lord gives a liberty, we can file the affidavit of evidence before the commission. The documents I have to prove the documents by oral evidence, but
no.
Let him give evidence in person.
That has not been also sought for.
No, I have. Prayer B. Prayer B of the summons.
In the affidavit.
Yes.
No.
I leave it on your lordship because I know because in the original I'm aware. I'm aware. Original side rules, civil procedure code. I'm aware the prayer is made. I leave it on your lordship. That.
Let him continue with that. Dispose of this application.
Let him prove his case on basis of the evidence, not on basis of affidavit. Not on basis of affidavit. Order 18 rule 4. It may be as per original side rule.
So far the documents are concerned, I will have to prove, but other questions.
No, you prove it in terms of the rules of the original saying.
Yes. I live.
This GA application. This application has been filed.
I wanted to inspect the documents in the meantime.
Inspection has not been made.
We have offered, they have not taken. It can't be, lordship, we can keep it open. We'll give once again, but we have offered from our side. It's their choice. They have not taken inspection.
So application. For conducting the examination of the witness in terms of which order? In terms of order dated?
13th of May, page 12.
Terms of order dated 13th May 2024. Mr. Aniruddha Mitro, learned advocate, appearing for the petitioner, submits that the judge's brief of documents, submits that by order dated 13th May 2024, Learned Advocate Commissioner was appointed for examination of the plaintiff's witness. However, at the time of examination of plaintiff's witness, it was discovered that the documents which are to be relied upon by the respective parties have not been filed in court. Upon leave being granted by this court, judge's brief of documents has been filed and
by the plaintiff.
Notice has been issued upon the defendants for inspection of the plaintiff's document. In the aforesaid backdrop, the plaintiffs may be allowed to proceed with the examination of their witness.
Oblige.
In view of such submissions, Learned Advocate Commissioner is directed to record the evidence of plaintiff's witness in terms of order dated 13th May 2024 as per rules of the original site. The application being GA9 of... Is there any other...
The report filing date has to be extended, will kindly. The order of Justice Mojumdar Malad record the last line.
Only one witness?
I have one. I have one witness. I have.
No, this 13th May order was allowed in respect of the plaintiff's witness only. Okay.
Plaintiff's
witness. Yes. Learned Advocate Commissioner is directed to file report
15th December, my lord.
By
15th December.
15th December.
No, I don't have to work in.
Okay.
15th December.
Liberty is granted to the Learned Advocate on record for the defendant to cause inspection of the plaintiff's document in the meantime.
And to find out that.
And file judge's brief of documents on behalf of the defendants.
The judge's brief before the commissioner or before the court? Could I file court? Shut up.
When the commissioner will start their proceedings?
Better to file.
After the puja?
Yes, first. After the puja. That is the reason I took 15th December. So you can work in November.
So, sir.
After vacation, my lord.
1 week?
My lord.
The inspection of the documents and filing of the judge's brief of documents in behalf of the documents should be completed by the defendants shall be completed within first week of November.
First to November.
November.
Then I
will continue by 11th November.
But we can continue with, because I have to prove my case through my documents. You got your 1 year time. But we are running from last April. He is aware.
So, prior to examination of your witness, that can be made?
Yes. But I can start with the examination. The documents will come from the defendant's side because I have.
Date kettedin.
They will do it.
Is granted. Let him.
Otherwise, this will become lingering.
Inspection kettedin. Time kettedin. Liberty is granted to inspect and.
So open.
Date kettedin.
Madam, sorry, madam, I missed the last Friday's program at Motion.
You are also from Motion? Oh.
I missed. I saw the pictures and all. I'm a 3-year course.
I was stuck in the jam. 2 hours. It took 2 hours to reach Motion.
That is the reason it didn't go.
In Danpuni, there was a mess.
If my lord is stuck in a jam, what happens to us?
No, you have not started.
So that's the reason. 2 hours up, down, the whole day.
Next reunion we will meet.
Yes, I will. Definitely. I'll definitely. In terms of the rules.
Item number 10.
My lord, my suit, my lord, where did my lord, my learned friends applicant, my lord, that matter, my lord.
Not one suit.
That matter, my lord, where my lord, learned friends application is there for
Where is the
reducing
judgment?
evidence, my lord.
You referred to one decision of this.
I was my lord, placing that judgment.
You have placed it, no?
No, I did not finish it. And, I think a copy, my lord, is handed over to my lords. That day only.
তারপর এটা কোনো কপি দিয়েছিল কিনা সিএইচএন এটা
My lord, it's a 2005 SCC online. It's reported in my lord
2006 3 CHN 451. I will start from the beginning only because it's a short chart. The issue was that the evidence cannot be laid by way of filing affidavit of evidence as is a practice before the courts below. As per the original side rules, the evidence has to be taken down.
No, reference.
Taken down before the commissioner by way of I think this chapter 14 of the original side rules saying that it will prevail over the civil procedure code. Rosh will kindly take chapter 14 once.
Yes.
It's the first rule. Evidence it's how taken. Upon hearing of any suit or matter in court or before a judge, the evidence of each witness shall be taken down by or in the presence and under the superintendence of the judge or one of the judges. Now, what we are on is the next part. Such evidence shall be taken down ordinarily in a narrative form, when in longhand, and in the form of question answer, when in shorthand, by such officers of the court as may be appointed for the purpose and shall form part of the record. The transcript of the shorthand note so taken shall be signed by the officer recording the note and be deemed the deposition of the witness and shall also form part of the record. So, two things are evident from this provision that one, it has to be in a narrative form, and once taken, the report of the commissioner will form part of this court's record. Now, these two things are what we can suffice from this provision. Now, what my learned friend relied upon is
PPC to
the civil procedure code. And she relied upon order 18. She had relied upon order 18. There are various provisions of which are there, rule 2, statement and production of evidence. Then she had relied upon rule 4, saying that in every case the examination in chief of a witness shall be on affidavit and copies. Has got it.
Yes.
And rule 4 under order 18. It says, in every case, the examination in chief of a witness shall be on affidavit and copies thereof shall be supplied to the opposite party by the party who calls him for evidence, provided that by the documents are filed and the parties rely upon the documents, the proof and admissibility of such documents which are filed along with the affidavit shall be subject to the orders of the court. This is the provision which my learned friend relied upon. So, two questions that arise before your lordship is whether order 18 rule 4 will prevail in the suit that is before your lordship over and above the provision which is there in the original side rules, and whether this rule at all applies to a suit in the original side jurisdiction, the ordinary original civil jurisdiction. This is not a commercial suit. Now, I had a two-pronged argument to this. One, this provision of Rule 4 was inducted by the Commercial Courts Act. Also, will find an annotation there. I'm sure Lordship's book is also has an annotation there beside Rule 4. Lordship will see it was substituted by Act 22 of 2002. And then it's inserted by the Commercial Courts, Commercial Division and Commercial Appellate Division of the High Courts Act 2015. The other argument that is there, and which is the most stronger argument is that the original side rules in any event, will always prevail over the civil procedure court in a chartered high court. Now, this whole issue was well settled before the judgment by the judgment that I have handed over to your lordships. But it's a division bench. And it's a division bench judgment of this honorable court.
Paragraph, which paragraph?
I will, my lord,
Five.
place, if my lord, may I not place the judgment once, my lord, because it will cover, my lord, all the provisions that my learned friend has, my lord, relied upon, and as well as, my lord, the provision that, my lord, I am relying upon. My lord, discussion has been made, which I will place, my lord, in short, and my lord, I will come to the conclusion after that. My lord, this, my lord, arose out of, my lord, lordship will kindly take paragraph 1 in the, my lord, the appeal. This is an appeal filed by the defendant appellant in respect of an order dated 20th January 2005. My lord, what was allowed by this order which was under appeal? That is there, my lord, before in Roman 1, my lord. The plaintiff respondent has given liberty to file a supplementary affidavit in respect of the witness who had already filed his examination in chief by way of affidavit. So, my lord, this was, my lord, which was allowed by my lord, the honorable single judge, and which was in appeal. My lord, there are, my lord, several submissions there, which lordship will kindly take. Paragraph 2 there. Mr. Such and such, learned senior advocate, appears on behalf of the appellant defendant, submitted that each and every deduction is erroneous and is liable to be set aside by reason of the deduction being contrary to the High Court rules, the Evidence Act, and the Code of Civil Procedure. The deductions are inconsistent with recognized principles of fair trial of a suit in the original side of this honorable court. With the submission, he drew our attention to Chapter 14 of the High Court rules original side, which deals with proceedings at the hearing of suits, record of evidence. So, my lord, this is the provision, my lord, which I have already placed before your lordship. Now, my lord, that provision is set up, and then, my lord, it proceeds in the manner. It is therefore clear that there are specific rules expressly and specifically dealing with the procedure for recording of evidence adduced by witnesses in course of trial of a suit. This field is occupied by subsisting High Court rules. The rule, so long it subsists, excludes the application of the provision of the Code of Civil Procedure, which provides examination in chief of witnesses by way of filing affidavits. He also drew our attention to Order 18, Rule 4. This is the provision which my learned friend relied upon.
Yes.
This is basically a substantive discussion between Chapter 14 of the original side rules and Order 18 of CPC. This judgment is all about that, Attention to Order 18, Rule 4 of the Civil Procedure Code, hereinafter referred to as the CPC, which has been introduced in the amended CPC with effect from 1st July 2002. It provides for examination in chief by way of filing an affidavit. It submitted this rule cannot be applied to the original side of the Calcutta High Court so long the rules contained in Chapter 14 of the High Court rules subsist. The operation of the amended provision of the CPC is excluded by the specific High Court rules. So, my lord, this was, my lord, the specific submission, my lord, before the division bench. My lord, the next submission was, he further submitted that Order 18, Rule 4 cannot and should not have any application in suits tried by a single judge of the original side of the High Court because of the provision contained in this rule is inconsistent with the specific rule relating to the recording of evidence at the hearing of the suit. My lord, attention was also drawn, my lord, to the Evidence Act, my lord. I'm not going into that because my learned friend has not relied upon any provision of, my lord, the Evidence Act. My lord, certain other, my lord, cases are also relied, which I'm, my lord, omitting for the time being. Full bench decision is also referred, my lord, at paragraph 12. In the said full bench decision of the Calcutta High Court, it was held if any rules framed by the High Court under clause 37 of the debtor's patent be inconsistent with or confers any additional powers besides what is granted by the CPC, the rules framed under clause 37 will prevail over the corresponding provision of the CPC. Well, there is a full bench judgment which is also, my lord, referred.
Yes.
Rashmi will kindly turn over and come to, my lord, paragraph 16 thereof. My lord, there's another, my lord, case that has been referred to, my lord, wherein, my lord, an honorable single judge of this, my lord, court has held, my lord, that, my lord, the provisions of, my lord, the original side rules prevails over, my lord, the Code of Civil Procedure. So the crux of the submission was that, therefore, it is, which is there at paragraph 17, therefore, it is clear that if Chapter 14 of the rules prevails over Order 18, Rule 4 of the CPC, then the question of filing an examination in chief by way of affidavit in a trial of suit by a single judge sitting on the original side of the High Court cannot arise. My lord, this was exactly, my lord, what, my lord, our contention is, my lord. My lord, After that, my lord, submissions were made on behalf of my lord the appellant therein, which is my lord there recorded my lord paragraph 21 onwards. Reliance my lord has been placed on my lord order 18 rule 4, section 16(1), which was my lord the amendment. We are not concerned with amendment my lord here. My lord, the reply my lord to the senior counsel's submissions is recorded my lord at paragraph 23, which I'm also my lord I'm not going into. The recordings my lord start from paragraph 25 onwards my lord.
Yes.
Which is there, my lord. My lord, next page, paragraph 25. The impugned order directed that all the witnesses of the plaintiff should file their examination in chief by way of affidavit, and thereafter all the witnesses of the defendant should put their examination in chief. So, my lord, this was, my lord, what was the order which was under appeal. Lord, she will kindly, my lord, turn over to my lord paragraph 30 thereof. My lord, rest, my lord, are submissions, which I'm not, my lord, repeating. Paragraph 30, which appears, my lord, at internal page 6. The Honorable Supreme Court observed that oral evidence is not imperative, which necessarily implies that in many cases, there may be affidavit evidence and there may be oral evidence. But it appears to us all these observations are not relevant for the purposes of this appeal because the High Court is guided by its own rules and not by the provisions of Order 18 CPC. So when this is a chartered High Court, my lord, it has its own, my lord, original side rules. It's not, my lord, guided, my lord, by the rules of CPC. My lord, paragraph 35 is, my lord, the conclusion, my lord, which, my lord, the Honorable Division Bench, my lord, arrived at. We have considered the points urged before us and must accept the position that if there is any conflict between the CPC and High Court rules of a chartered High Court, the rules will prevail. We have further found from the CPC and we have considered section 129 of CPC and also order 49 rule 2 of the CPC. And we have found that there cannot be any doubt that the order 18 rule 4 cannot play a role when a suit is being tried before the original side of the High Court. So, my lord, this, in my respectful submission, this point, my lord, is well settled by this judgment, my lord. Now, my lord, it has gone on to, my lord, record the submissions there, my lord, at paragraph 36, my lord, which, my lord, I'm not repeating. Paragraph 37, my lord, the Honorable Division Bench has, on its own, my lord, has recorded a judgment of the Supreme Court, my lord. We have also found the same opinion expressed by the Honorable Supreme Court in Iridium India Telecom Limited. Well, I'm not, I have not multiplied, my lord, the judgments because, my lord, so repeated. And, my lord, paragraph 38, my lord, records the final finding. Accordingly, we are unable to accept the directions given by the Honorable First Court as a correct procedure to be followed in the original side, and we set aside, and, my lord, the order was set aside. So, my lord, it's, my lord, crystal clear from this, my lord, from this judgment, my lord, that order 18 rule 4, my lord, which, my lord, my relevant friend has relied upon, my lord, to proceed with the, my lord, recording by way of filing affidavit, evidence by way of affidavit, my lord, is probably not, my lord, the correct procedure to be followed, my lord, in a suit in the original side jurisdiction. And, my lord, the only other, my lord, issue that may come up is, my lord, though, my lord, my learned friend has not taken that point in her submission, but it may come up in reply, my lord. I'm just trying to cover it up. That this, my lord, is happening by way of commission. So this is not, my lord, before your law. Maybe, my lord, I did not hear it on my, I have a, my lord, a memory of a goldfish. It may happen. But I'm still trying to cover it up. That, my lord, is happening before, my lord, the commissioner. So, my lord, this whole thing, my lord, is not before your lordships. Hence, this does not apply. My lord, this, you'll get your chance, my lord. Reply the code. Reply the code. So, my lord, I'm just trying to cover up that point once. I'm not going into, my lord, in the details of this judgment, my lord, because of, my lord, the lordship will find it from the, my lord, the cost title of it. I don't want to, my lord, place the whole judgment because there are several issues, my lord, which were dealt in this, my lord, matter. I'm just, my lord, relying upon paragraph 16, I'm not placing the whole judgment. On 2024 3 SCC. 3 SCC 336. Under paragraph 16, my lord. In terms of Order 26 Rule 10, the Commissioner has to submit a report in writing to the court. Report of the Commissioner and the evidence taken by him constitute evidence in the suit and form part of the record. My lord, this is, my lord, the long and short of, my lord, the whole judgment. I'm not going, because of the nature of the judgment, I'm not, my lord, placing the whole thing, my lord. There are several issues. Right, reported judgment copy.
I replied to the verbal that
Yes, my lord. This is, my lord, the long and short of it, my lord, that the application that, my lord, my learned, and one more thing, my lord. My learned friend has come up with this application seeking, my lord, a leave from your lordship to, my lord, file, my lord, the examine by prayer, my lord. I don't understand, but it says that it will be granted to your petitioner defendant number 1 to give examination in chief by way of affidavit. Right? She has to probably seek leave to file an affidavit in evidence. But anyways, no special, my lord, ground has also been made out under, my lord, this application by which, my lord, my learned friend, my lord, seeks leave of this court, my lord. The application, my learned friend has not placed, it's her application. But, my lord, I will, my lord, take a minute, my lord, to place this application once before your lordship. Because, my lord, I have not, my lord, thought any direction for filing opposition. So, my lord, there are certain, my lord, averments, my lord, which, my lord, I had to oppose. I am not filing the opposition. So, anyways, my lord, the judgment is passed. My lord, the opposition is not, my lord, filed, and, my lord, the submissions are not, the pleadings are not, my lord, admitted. My lord, it proceeds.
My learned friend is arguing the final hearing. Lordship will be pleased to record that he has waived his right to file the affidavit. Otherwise, will not
I've not waived my right. Since it's a point of law, my lord, I feel, my lord, on factual basis, there is no need, my lord, to file an opposition. The, my lord, statements here may be recorded as not being, my lord, admitted by me. The rest of it, my lord, is a completely, my lord, legal proposition which we are arguing. We're not going into the facts. Neither, my lord, the trial of the suit is happening before your lordship here.
Yes.
My lord, it proceeds, my lord, this how the suit was filed, my lord. Then, my lord, the prayers, my lord, are set out in paragraph 4. And then, my lord, it proceeds on the basis that, my lord, certain orders are, my lord, at paragraph 6, my lord, at page 6, my lord, paragraph 6, paragraph 7, my lord, certain orders, my lord, are highlighted, my lord, though I don't find, my lord, the reason of, my lord, highlighting these orders. Then, my lord, what my learned friend proceeds is, once again, on the basis of, my lord, Order 18, Rule 4, my lord, no factual, my lord, reason has been set out in this application, which, my lord, by which, my lord, my learned friend is seeking leave. So, my lord, no special ground factually has been made out as to why, my lord, my learned friend wants to file the examination in chief by way of affidavit. Only the reason that has been highlighted is, my lord, it's a legal provision, Order 18, Rule 4. So, my lord, she should be permitted, my lord, to file by way of examination, by way of affidavit. That's, my lord, my submission. My lord, the application may be dismissed, my lord.
Lord, it is an admitted position in this case that on an application filed by my learned friend, my lord, Commissioner has been appointed to take evidence. Now, my lord, this is a direction which has been given by in the present suit, which has been filed under the original side rules, and such direction has been given by this honorable court in exercise of the power under Order 18, Rule 4 of the CPC. My lord, my learned friend cannot pick and choose a part of the provision and say that I'll rely on a particular portion and I shall not rely on a particular portion. Lordship, the issue is whether there is a conflict between the original side rules and the CPC. If there is a conflict, my lord, in such an event, my lord, the original side rule will prevail. Now, my lord, kindly take order 14 rule 4. Order 14 rule 1 first. Evidence how taken. Upon the hearing of any suit or matter in court or before a judge, the evidence of each witness shall be taken down by or in the presence and under the superintendence of the judge or one of the judges. Now, my lord, if we go by the original side rules, my lord, order 14 rule 1, simpliciter, my lord, then, my lord, there is no scope, my lord, for appointment of any commissioner to record any evidence, my lord. Because under the rules, my lord, it says, upon the hearing of any suit or matter in court or before a judge, the evidence of each witness shall be taken down by or in the presence and under the superintendence of the judge or one of the judges. My lord, the commissioner cannot be equated with the honorable judge, my lord. My lord, however, my lord, by introduction of order 18 rule 4, my lord, in the CPC, in order to save the time of the court, my lord, because there so many matters are pending and the recording of evidence in the court would take a lot of time, my lord. Therefore, my lord, a provision was introduced apart from filing of affidavit in chief, the appointment of commissioner, which is, my lord, order 18 rule 4 sub rule 3.
Steering to file custody.
Rule 2, rather, the evidence, cross-examination and re-examination of the witness in attendance, whose evidence examination is chief by affidavit has been furnished to the court, shall be taken either by the court or by the commissioner appointed by it, provided that the court may, while appointing a commission under this sub-rule, consider taking into account such relevant factors as it thinks fit. The court or the commissioner, as the case may be, shall record evidence either in writing or mechanically in the presence of the judge or of the commissioner, as the case may be, and where such evidence is recorded by the commissioner, he shall return such evidence together with his report in writing signed by him to the court appointing him, and the evidence taken under it shall form part of the record of the suit. The commissioner may record such remarks as it thinks material respecting the demeanor of any witness while under examination, provided that any objection raised during the recording of the evidence before the commissioner shall be recorded by him and decided by the court at the stage of arguments. The report of the commissioner shall be submitted to the court appointing the commission within 60 days from the date of issue of the commission, unless the court for reasons to be recorded in writing extends the time. Now, my lord, this provision, which is in order 18.4 rule 2 and thereafter, my lord, does not find any place in chapter 14 rule 1, my lord. Chapter 14 rule 1 only finds says, my lord, that an evidence has to be recorded in the open court, because in front of the judges means it has to be recorded in the open court, my lord. And then it has to be what my learned friend is insisting. In one part, when he says he is relying on the provisions of order 18 rule 4. In fact, it has been in vogue in this present proceeding where, my lord, the commissioner has already been appointed who is recording evidence, my lord. Therefore, my lord, the one breath my learned friend is saying that the provisions as contained under order 18 rule 4 of the CPC are not applicable in the present suit, as the chapter 14 rule 1 of the original side rules does not permit for the same, or there has not been a consequent amendment in the original side rules which would allow the order 18 rule 4 of the CPC to be applied with in the suit in the original side. To this, my lord, my submissions are, my lord. So far as the first part is concerned, my lord, recording of evidence in court, my lord, the chapter 14 rule 1 clearly says that it has to be in the presence and under the superintendence of the judge or one of the judges. However, my lord, in consonance with the provisions of order 18 rule 4, my lord, a commissioner has been appointed to record evidence. Lordship has directed, my lord, not only in this matter, but in several matters, my lord, where the commissioner has been appointed to record evidence, my lord. Therefore, my lord, this submission of my learned friend, my lord.
No. What was the position prior to 2002?
Prior
There
to
was a
2002,
commission.
the
No. There was commission for recording the evidence of the witness.
No.
What no?
Prior to 2002,
Come to order 26. Order 26 is a commission to examine witnesses. So, even if ordered in Rule 4, 2002, it was incorporated to expedite the proceedings, there was a provision for appointment of a commissioner for examination of the witness. So, it is not that after Order 18, Rule 4 was incorporated, advocate commissioner was appointed.
But it was not a regular phenomena. It was an
No, if the court exercised any discretion, it was under Order 26, Rule 4. What you are submitting is, since one part of the order in Rule 4 has been taken into concern by advocate appointing advocate commissioner, so the other part also to be taken into consideration. That is not the case. Order 26, Rule 4 is the examination by commission. So that power has been exercised by the court in appointing the advocate commissioner. So there is no conflict to that.
I am not saying there is a conflict. Order 26, Rule 4.
No. Your
That 26
submission is that one part of Order 18, Rule 4 has been taken care of by the learned judge appointing advocate commissioner under Order 18, Rule 4.
My lord has
Then
said
why the first portion of Order 18, Rule 4 should not be taken into consideration?
my lord
Now
has
the
said,
appointment of advocate commissioner has not been made under Order 18, Rule 4. Order 26, Rule 4.
Order 20, just sorry. Order 26. Sorry.
See?
Oh. Yes, your lordship. Where does Order 26, Rule 4? Sorry, I was looking in original side.
You complete your argument.
Persons for whose examination commission may issue. Any court may in any suit issue a commission for the examination on interrogatories or otherwise of any person resident beyond the local limits of the jurisdiction. Any person who is about to leave such limits before the date on which he is required to be examined in court, and any person in the service of the government who cannot, in the opinion of the court, attend without detriment to the public service, provided that where under Rule 10 of Order 16, a person cannot be ordered to attend a person in court in prison, a commission shall be issued for his examination if his evidence is considered necessary in the interest of justice. So, my lord, Order 26, Rule 4, my lord, A, B, C, my lord, the clauses are circumscribed, my lord. Where, my lord, it has been said, my lord, any person resident beyond the local limits of the jurisdiction of this honorable court, it has to be. Now, the plaintiff, my lord, or the defendants, my lord,
Can we return to
do not stay, my lord, outside the jurisdiction of this court. The plaintiff,
Yes, continue.
A, any person resident beyond the local limits of its jurisdiction, any person who is about to leave such limits before the date on which is required to be examined in court, and any person in the service of the government who cannot, in the opinion of the court, attend without detriment to the public service. So, my lord, under Order 26, Rule 4, my lord, in order to have the commissioner appointed, my lord, these three conditions, my lord, which have been laid down in Order 26, Rule 4, subsection 1, A, B, and C, were required to be fulfilled. My lord, my learned friend did not take shelter under Order 26, Rule 4, or any of the sub-rules 1A, B, and C to have an order of commissioner being appointed, my lord.
Now, what was the ground then?
That was a ground that the gentleman is ill and it would expedite the hearing of the suit, and for such reason the commissioner should be appointed.
Okay.
Had it, my lord, a case of Order 26, Rule 4, then, my lord, that would have been a different situation. I could not have argued that point at all. But my learned friend's case is that in recording of evidence has to gone down strictly in accordance with Chapter 14, Rule 1, and provisions of Order 18, Rule 4 CPC have no manner of application. This is what my learned friend is arguing today. Then, my lord, the entire evidence that has been recorded before the learned commissioner, my lord, becomes void.
Okay.
This is what I'm submitting, my lord. Because Order 18, Rule 4, my lord, your lordship will find, is totally a different provision that was introduced in 2002. If the situation would have covered in Order 26, Rule 4, my lord, there was no need of amendment of CPC and introducing Order 18, Rule 4 of the CPC in the year 2002. 2, 3, 4 could not have been introduced, my lord. This power was made appointment of commissioner, and the power to be exercised by the commissioner for recording of evidence was an elaborate power which has been given under Order 18, Rule 4 CPC, subsequently in 2002, to take care of all types of situations.
Yes.
This is my first point, my lord, which has fallen from your lordship. Yes, commissioner were being appointed, my lord. In fact, I had the occasion, my lord, to cross-examine a witness, my lord, by way of commission, Mr. Ramakrishna Chaudhary, learned advocate, my lord, Ketan and Company, my lord, who was staying in Alipur, my lord. This honorable court had appointed commissioner to examine him. I am not bereft of this. What I am submitting, my lord, and nowadays, my lord, after the introduction of this Order 18, Rule 4 CPC, my lord, in this honorable court, my lord, in order to expedite the hearing of the suit, my lord, are appointing the learned advocates as commissioner to record evidence, my lord. And this is in consonance with the provision as contained under Order 18, Rule 4 and not under Order 26, Rule 4, 1 ABC, my lord. This is my first submission, my lord. Second submission which I am making, my lord, is this, that this Order 18, Rule 4, my lord, is not in contradiction with Chapter 14, Rule 1. Chapter 14, Rule 1 is, my lord, silent with regard to the commission. My learned friend is only relying upon one part of the Chapter 14, Rule 1, but other part my learned friend is ignoring when he says that it has to be in a narrative form, in a form of question answer. This is where his objection lies, my lord. If this point which has been argued by my learned friend is accepted, my lord, then this honorable court, my lord, could not have appointed any advocate commissioner for the purpose of recording of evidence, my lord. Such evidence shall be taken down ordinarily in a narrative form when in longhand and in the form of question answer when in shorthand by such officer of the court as may be appointed for the purpose and shall form part of the record. My learned friend is relying upon this part of the provision of Chapter 14, Rule 1. According to my learned friend, my lord, because if it has to be in a narrative form when in longhand and in the form of question answer when in shorthand, this means that, my lord, it has to be only oral evidence. It cannot be an evidence by way of affidavit, my lord. This is what precisely my learned friend is arguing. Then, my lord, my learned friend should also confine his submissions, my lord, that how come a commissioner can be appointed when the honorable judges are not taking the evidence under Chapter 14, Rule 1. Because, my lord, this honorable court, my lord, had come to the, by way of practice, my lord, has evolved that the procedure that has been laid down under Order 18 Rule 4 of the CPC is more practical and expedient, and it is not in conflict with the original site rules, my lord. That is why, my lord, this honorable court has been pleased to appoint learned commissioners, my lord, to take evidence on record. And my learned friend has not shown as to how the provisions of Order 18 Rule 4 are in conflict with the Chapter 14 Rule 1 of the original side rules, my lord. The only, my lord, the decision which my learned friend has cited, my lord, kindly take that decision. This my lord, the filing of affidavit in chief, my lord, also saves time, my lord. It is not that the witness who will be adducing evidence by affidavit on evidence, my lord, will not be cross-examined. Opportunity to the defendant, my learned friend would have an objection if his right to cross-examine the witness would have been deprived. Now kindly see what was the matter in issue, my lord, which was being heard by the Honorable Division Bench, my lord, in the year 2005, my lord. My lord, the paragraph 2 of that order, my lord, I have got another version, if it tallies with or not. The said order contains the following directions. The plaintiff oblique respondent given liberty to file a supplementary affidavit in respect of the witness who had already filed his examination in chief by way of affidavit. The plaintiff has been directed to file further affidavit evidence in respect of other witnesses proposed to be called by the plaintiff. The defendant appellant has been given liberty to file their affidavit evidence in similar fashion within 2 weeks thereafter, even before the cross-examination of the first witness is complete. My lord, here is a case, my lord, if I have understood the entire judgment, I have read it, is that plaintiff had filed his examination in chief. And thereafter, my lord, the plaintiff became little wise, my lord. He wanted to improve his case, my lord. Therefore, he wanted to file a supplementary affidavit of evidence. My lord, this was one of these. The second was that all other plaintiff's witnesses were also directed to file their affidavit in chief in one go. And thirdly, the defendant. Oh, sorry, after vacation. Affidavit, all the witnesses of the defendant were also directed to file their affidavit in chief before the cross-examination of the first witness is complete. This was the order under challenge which was being considered by the Honorable Division Bench, my lord. But even after this judgment is passed, my lord, the court has said that, my lord, why the affidavit in chief was kindly come to paragraph 27, whether which paragraph it is, can you tell?
Anjan Babu,
It is photo number paragraph.
Commercial Courts Act is CPC tech rejected. Commercial Courts Act.
Thank you for that.
Yes. Which paragraph you are referring to?
Lord, just trying to tell you with my copy is different person. Mr. SP Sarkar. Just yes. Now kindly take paragraph 23 of your lordships. In reply, Mr. Chaudhary submitted that the defendant never accepted the said direction for filing the supplementary affidavit. It is well settled that in an examination in chief, a witness should not be permitted to improve his case. Allowing a witness who has already concluded his examination in chief by filing his affidavit is like recalling the same witness for further examination in chief. This is not permitted. When a witness can be recalled has been provided in Order 18, Rule 17 of the CPC. The court may at any stage recall any witness who has been examined and put such questions to him which the court thinks proper. This is not the same as allowing the same witness to be recalled for the purpose of giving evidence for further examination in chief just because the evidence already adduced by him is not considered by the plaintiff to be comprehensive. It was contended by the respondent that the first witness did not finish or concluded his examination in chief. According to Mr. Sarkar, it should not be deemed that he was still in the box and his examination was not concluded yet. This contention is untenable. The moment the examination in chief is filed, his examination in chief is deemed to be concluded. This is not a matter of individual perception, as contended by the respondent in this appeal. So this was one of the basic issue, my lord, which was under challenge before the Honorable Division Bench. Recalling of the same witness for further examination in chief is permitted in exception cases if the court so desires only after the examination in chief and the cross-examination and re-examination is concluded. The impugned order directed that all the witnesses of the plaintiff should file their examination in chief by affidavit, and thereafter all the witnesses of the defendant should put their examination in chief by way of affidavit simultaneously. It is impermissible even if one presumes that Order 18 Rule 4 of the code applies. Even under Order 18 Rule 4, this procedure of filing of examination in chief by all the witnesses of the plaintiff and the defendant is not permissible. Then, my lord, it speaks about 138, the order of examination. The defendants have the right to decide, not applicable. Paragraph 33, my lord, kindly come to. Lordship, it would be 29, I think so. A party can file an affidavit
Yes.
A party can file an affidavit by way of examination in chief. He can also compel a person under his direct control to file an affidavit. Whenever a third party is proposed to be called as and when required, it is not possible for the defendant to adduce examination in chief of that witness by way of affidavit. This problem was discussed in Salem Advocate Bar Association versus Union of India. While discussing the validity of the amendments sought to be introduced in the CPC, the Honorable Supreme Court, in applying Order 18 Rule 4, that it was not imperative to have the examination in chief always by affidavits. So this was the finding which the court has recorded. It is not imperative. It may be, it may not be. But it does not say that no, it cannot be filed by way of affidavit in chief. My lord, in fact, Salem Advocate Bar Association, my lord, it relates to a case of Madras High Court. Madras High Court is, your lordship, is like Calcutta High Court is a chartered High Court, my lord, where like Bombay, Calcutta and Madras, where the original side rules are there. The Honorable Supreme Court observed that oral evidence is not imperative, which necessarily implies that in many cases there may be affidavit evidence and there may be oral evidence. But it appears to us all these observations are not relevant for the purpose of this appeal because the High Court is guided by its own rules and by the provisions of Order 18 of the CPC. কি বলেছি আমি যেটা বলেছি পুরোই বলেছি
Yes.
Now, then paragraph 35, my lord, it is with regard to the defendant being called upon to file his affidavit in chief. This has been dealt with in paragraph, my lord, 31 and 32. The court did not accept that calling upon of the defendant. Then kindly come to paragraph 35, I think. It starts with, we have considered the points urged before us and must accept the position that if there is any conflict between the CPC and High Court rules of a chartered High Court, the rules will prevail. We have further found from the CPC and we have considered the section 129 of CPC and also under 49 rule 2 of the CPC. And we have found that there cannot be any doubt that the order 18 rule 4 cannot play a role when a suit is being tried before the original side rule of the High Court. But this was the view my learned friend could have relied upon. But my lord, in the practice in vogue, after this judgment, which was delivered in the year 2005, my lord, there are cases, my lord, where in the original side also, the provisions of Order 18 Rule 4 CPC have been applied for. It does not speak about Order 18 Rule 4.1 only. It speaks about the entirety of the Order 18 Rule 4 of the CPC, which includes the appointment of commissioner for recording of evidence. And in this judgment, my lord, the court has said that why it was required oral evidence, my lord, because the court had to see the demeanor of the witness. My lord, Order 18 Rule 4, lordship will find, also provide that the commissioner can examine the demeanor of the witness and in his report, he can give such remarks for the consideration of the court. In light of this paragraph, my lord, if it is taken to be a precedent which is binding, my lord, and which then in such an event, my lord, no court could have ever appointed the advocate commissioner under Order 18 Rule 4 CPC for recording of evidence, save and except in a situation which is specifically earmarked under Order 26 Rule 4 CPC. And in my respectful submission, my lord, adducing affidavit on evidence by way of affidavit, examination chief, is not in infringement of the provisions of Order 14 Rule 1, my lord. Because, my lord, here the party is being cross-examined, my lord. The witness is being cross-examined by the either plaintiff or the defendant's counsel on the appearing on the other side, as the case may be. And, my lord, these are being done by way of question answers only. Filing of affidavit on evidence, my lord, it reduces the time which it will take in proving the case, in leading the evidence in examination in chief. With that object in mind, my lord, the provision was introduced in the CPC. And, my lord, the Commercial Court Causes Act 2015 has also adopted the same, my lord, that where it has been permitted that affidavit in chief should be filed. And, my lord, there is no provision, my lord, or there is no circular or notification by the Honorable by the administrative side of this Honorable Court, my lord, excluding the applicability of provisions of Order 18 Rule 4 CPC. So I say, my lord, in my...
On the other hand, you can also see that there was no requirement of having a amendment in Commercial Courts Act to have the evidence in affidavit evidence. If it was implied that already in Rule 4 was already there.
My lord, Commercial Court Causes Act, my lord, your lordship will
Am I clear to you?
Yes, yes.
What was the necessity to have an amendment of Order 8 Rule 4 in case of commercial suits?
No.
If impliedly Order 8 Rule 4, Order 18 Rule 4 in the CPC is applicable.
Why it was required, my lord, I have not brought the Commercial Causes Act before your lordship, but your lordship will find not only there was an amendment under Order 18 Rule 4, my lord. In fact, Order 37 Rule 3 was also been amended. Order 37, my lord, summary judgment. Because the Commercial Causes Act is a separate enactment altogether, where, my lord, it deals with a different type of situation. Kindly come to Order 37, my lord. Your lordship will find. My lord, your lordship knows a suit is being filed under Order 37 Rule 3, my lord. And under the original side rules, my lord, we can also apply in a suit for a summary judgment under Chapter 13A of the original side rules, my lord. And the Commercial Causes Act, my lord, the original side rules were applicable. Kindly come to Order 37 Rule 3, my lord. Here the amendment has also taken place. And the Commercial Causes Act, my lord, for summary judgment, a separate procedure has been introduced. Lord, in my book it is not showing, but I am aware because I had filed a suit, my lord, under Order 37, Rule 3, my lord, which was not being permitted by this Honorable Court, my lord, because Commercial Causes Act provide for a separate procedure for summary judgment, my lord. My lordship will find under Chapter 13A of the original side rules, my lord, a procedure for summary judgment is there, my lord, under Chapter 13A.
That's all.
My lord, therefore, my lord, this introduction of Amendment of Commercial Causes Act, my lord, in number of places, my lord, the provisions of CPC have been amended to bring for the purpose of Commercial Causes Act 2015. It is not simpliciter with regard to Order 18 Rule 4 CPC. But mere fact that Commercial Causes Act 2015, for the purpose of the Commercial Causes Act, my lord, the provisions of CPC has been amended, my lord, does not mean that, my lord, the other provisions of Order 18 Rule 4 will not apply to the original side suits of this Honorable Court, my lord. Because, my lord, there are various provisions of CPC, my lord, which are being made applicable by this Honorable Court in the suits. Wherever there is a original side rules are silent, or where it is not specific, then, my lord, the CPC comes into play, my lord. It has to be in conflict. I do not find, my lord, recording of affidavit on evidence by way of examination in chief, my lord, is in conflict with any of the provisions of the original side rules, my lord. And since my learned friend has already taken advantage of Order 18 Rule 4 CPC, my lord, have got the order commissioner being appointed, my lord, it is not open for my learned friend to contend that the Order 18 Rule 4 CPC will not apply to the original side suit.
Okay.
These are my submissions, my lord.
She had a more vivid, my lord, argument in reply rather than, my lord, by
I
placing a
was
case
dealt
for the
with
first
your
time.
judgment
Only
on-
one thing, my lord, since, my lord, she had a longish argument in reply. My lord, in the original side, my lord, the commissioner for recording evidence is not appointed under Order 18 Rule 4, but under Chapter 22 of the original side rules. So, my lord, the question of, my lord, me invoking Order 18 Rule 1, then, my lord, saying that Order 18 does not apply, my lord, does not arise. And, my lord, even if, my lord, for the sake of argument, I take that I had appointed the commissioner by, my lord, invoking Order 18 Rule 1, even then, my lord, the procedure has to be as per the original side rules. Those prevail, my lord.
Chapter 22 rule.
Yes, my lord. Chapter 22, Rule 1.
My
This
lord,
is,
that
my
is
lord,
under
that
Order
is
26 Rule 1 or 4. It relates to Order 26 Rule 1
Chapter
and 4.
22 is motions and rules, Nisi.
Commissions to examine.
commissions
22.
to examine witness, my lord.
Application for commission and application for the issue of commission under 26 Rule 1 or 4 of the code. It is limited to Order 26 Rule 1.
Chapter 22.
Yes.
Chapter 22, my lord, of the, my lord, the original side rules, my lord.
1, 2.
Rule 1 and or 4. So it is confined to Order 26 and the circumstances as narrated in Order 26 Rule 1 ABC. It does not go beyond that.
Ashwin.
I think, my lord, time has, my lord, 2005 is long back, my lord. I think we all need a fresh judgment on this point, my lord.
This is an application seeking leave.
Yeah, my lord, stay for 1 minute, my lord.
I think, my
Yes,
lord, is
yes.
Uh,
dictating the judgment or, my lord.
One of my matters called on. Can I have a leave?
You can leave. Who is there to represent you?
My lord is dictating the judgment today?
Yes.
You know.
This is an application seeking leave to examine the witness of petitioner defendant number 1 by filing examination in chief by way of affidavit. Miss Manju Agarwal, learned advocate, appearing for the petitioner, submits that
I come back within a second, my lord. 1 minute. I make a phone call and come back. Lord should give dictation. I will not. Just
okay.
make the.
Learned advocate appearing for the petitioner submits that at the instance of the petitioner defendant number 1, at the instance of the plaintiff, advocate commissioner was appointed to examine the witnesses of the parties. This was for both the parties. Both the parties. The witnesses of the plaintiffs have already been concluded. The defendants intend to examine its witness by filing affidavit of examination in chief. Order 18, Rule 4 of the Code of Civil Procedure, hereinafter referred to as CPC, clearly envisages that the examination in chief of a witness can be held on affidavit. There is no such bar in proceeding with the evidence of the defendants by accepting the examination in chief on affidavit. Although Chapter 14 of the original side rules of this code provides that the examination of witnesses shall be taken down in presence of the judge in a narrative form and in question answer form, but subsequent amendment in 2002 of the CPC incorporating Order 18 Rule 4 is to expedite the process. She further submits that the commission once issued for examination of the witnesses under Order 18 Rule 4 of the CPC makes the entire provisions applicable. In light of her aforesaid submission, she prays for leave to examine petitioner defendant number 1's witness by filing examination in chief on affidavit before the advocate commissioner. On the contrary, Mr. Saurabh Sengupta, learned advocate appearing for the plaintiff, submits that Chapter 14 of the original side rules clearly indicates that the examination has to be made in narrative form, in writing. Referring to a decision of this court passed in Howrah Motor Company Limited versus Exide Industries Limited, reported in 2005 SCC Online Calcutta 282. He submits that since there are specific rules expressly and specifically dealing with the procedure for recording of evidence under Chapter 14 of the original side rules, such rules will prevail over Order 18 Rule 4 contained in the CPC. He also indicates that the Commission for Examination of the Witness has been issued under Chapter 22 of the original site rules. I think the other decision, Mr. Sengupta, is not relevant in this case because it is of local commission.
I have not dealt with because I found it not to be relevant. It was
is
with
not
regard to the appointment of
Even,
advocate.
my lord, this judgment already says that, my lord, it forms part of the record, and my lord, chapter 14 also says that it will form part of the record. So, my lord,
Order 26, Rule 9 case it was.
So I am not dealing with this particular judgment. Having heard the learned advocates for the respective parties, the issue which needs to be examined is whether recording of evidence by way of affidavit can be proceeded before the advocate commissioner. In order to examine such question/issue, it would be profitable to refer to Rule 1 of Chapter 14 of original site. Chapter 14 set out corner. Rule 1 of Chapter 14. Set out করে দিন ওখানে করে দিন and Order 18 Rule 4 দুটো প্রভিশনকে পরপর রাখবেন এখান থেকে বার করে নেবেন বই থেকে চ্যাপ্টার 14 আর সিপিসি আমি বই দিয়ে দেবো আপনাকে সিপিসি অর্ডার 18 From the provisions contained in Chapter 14, it manifests that the recording of the evidence in a suit in the original site of this honorable court should be taken down ordinarily in narrative form when in longhand and in the form of question answer when in shorthand. It is also relevant to note that no such amendment to the aforesaid rule has been made for recording evidence by way of affidavit, by way of examination chief on affidavit. At this juncture, the question arises whether provisions of Order 18 Rule 4 of the Civil Procedure Code can be adhered to. In Howrah Motor Company Limited Supra, quote করবেন paragraph 10 to 17. From the aforesaid observation, it is palpable that the provisions of Order 18 Rule 4 of the Civil Procedure Code, where is that? Cannot be applied in case of suits in the original site of this honorable court. Ms. Agarwal, learned advocate appearing for the defendant number 1 petitioner, would argue that since the learned advocate commissioner was appointed under Order 18 Rule 4 of the Code of Civil Procedure, hence the entire provisions will apply, including recording of evidence by way of affidavit. Order. This code humbly differ on the submissions advanced on behalf of the petition defendant number 1 in this regard. It has been rightly pointed out by Mr. Sengupta, learned advocate for the plaintiff, that the commission for examination of witness has been allowed and proceeded with in terms of chapter 22 of the original site rules. In view of the above, this court does not find any merit in the application. Accordingly, the application BGA 11 of 2024 stands dismissed.
Just for my, Lordship, whatever the Lordship order has been
Not
given,
now.
I'm not saying. Kindly just take chapter 22. Because lastly, my
I have
Lordship
referred to it. Please, I will not do that. Excuse me. এটা পড়ে ওটাকে কোড করে আমাকে পাঠিয়ে সিপিসিটা এখানে আছে No, books are here. Thank you very much. Thank you, Mrs. Agarwal. Thank you.
Obliged, please.
এটা করে টাইপ করে পাঠিয়ে
Lordship, I appear on behalf of the plaintiff. The instant suit, we have instructions to withdraw, my lord.
Who is for the defendant?
Service. Lordship had directed us to serve and come. The service was completed, my lord. I'm filing the affidavit of service.
So who is the learned advocate?
My lord,
Who was the learned advocate for defendant?
my lord, Mr. Chaudhary had been appearing, Shobhushashi Chaudhary. He was, I think, my lord, instructed by Mr. Mr. Shondip Datta. He was the learned advocate on record earlier in this matter, my lord.
So you have not given notice to him?
No, we had served directly upon because they said they were not being instructed to appear. So we served directly upon the company, my lord.
Where is Mr. Chaudhary or whoever is appearing? He has intimated you that there is no instruction to appear on behalf of the defendant.
Yes, my lord.
Where is that?
There is no written instruction. We tried servicing earlier, my lord. They refused. So that's why we served directly upon the company because, my lord, earlier it was Hooghly Printing. There was a subsequent amalgamation between Andrew Yule and Hooghly Printing, apropos which Andrew Yule was made as a party defendant in place instead of Hooghly Printing.
GA টা কি আছে? GA 9 or 16? It is appear করছে GA 9 or 16? Two suits are there.
Yes, my lord, two suits. This is
Both,
the first
both you,
suit.
both you will withdraw.
No, no, only for CS 268, my lord.
No, give a notice to him. আসুন তো। Where is that letter? He has refused.
No, no, my lord. We had intimated him. They didn't appear thereafter.
No, no.
There is
After
a
the
letter of
passing of the order on
22nd of
2nd September, you have intimated.
My lord, we served him a letter of the amended copy of the
Affidavit
plaint
of
on 22nd of November.
Service filed on behalf of the plaintiff is taken on record. Your written instruction to withdraw the suit, Mr. So and so, learned advocate. আচ্ছা, হয়ে যাবে।
Order that কবে থেকে করে appear করা বন্ধ? But they had last appeared on 13th of February 2024. After that, they have stopped appearing in the matter. Your Lordship will kindly look at the orders 14 March 2024, 18th July 2024 of your Lordship, and then again on 2nd September 2024 of your Lordship.
Issues have been framed. Issues.
No, my lord. Inspection, discovery, all those things are not complete. So issues have not been framed.
अच्छा. কি বললাম? Submits that upon a written instruction from the plaintiff he intends to withdraw the suit. None appears on behalf of the plaintiff.
All on behalf of the defendant.
Defendant, sorry. Defendant. Affidavit of service, track report. Affidavit of service shows item delivered to the defendant company by order dated 2nd September. Direction was issued 2024. Direction was issued upon the plaintiff to intimate the learned advocate for the defendant. Mr. Pratik Ghosh, learned advocate for the plaintiff, informs the court that he has refused to accept.
Yes, my lord, because your Lordship would kindly take the earlier orders, my lord. After 14th, after 13th of February 2024, the defendants the advocates rather, have stopped appearing on behalf of the defendants, my lord. There have been 3 orders passed in the matters, my lord. 14th March 2024, 18th July 2024, and 2nd September 2024.
Informs the court that the learned advocate for the plaintiff has not been intimated in terms of order dated 2nd September 2024 in writing. Learned advocate for the plaintiff is directed to comply order dated 2nd September 2022, informing the learned advocate for the defendant. When can information be given?
We will give it today itself. Lordship can keep it on Monday. We'll give it today itself.
अच्छा, written instruction is kept on record. Monday to record. Monday.
The next matter also can be made returnable on Monday. Same parties.
12.
So we'll not be withdrawing, but that matter can also come up in the list on Monday.
12.
Sorry, madam.
12.
Yes, 12.
With 12. দুটো যা আছে সেরকমই থাকবে। To be mentioned রাখতে হবে। To be mentioned. Under to be mentioned.
Great.
Item number 13.
I beg to appear for the plaintiff. There was a direction upon the register origin side to furnish a report.
Regarding,
my lord, the origin share certificates have been put into custody of the original side, register origin side. As per some order, my lord, the order is not available at this moment. Well, I have met the register origin side personally. This is his office, my lord. I've intimated him about this order.
Which order?
The order passed in the last occasion. Kindly have it.
The upload already.
I believe this order has not yet been communicated to the registered original side from this court, my lord. He was unaware of this order.
Oh, the report is here.
Is there? Oh, I went.
This
Really?
is also
Old
communicated to the office. Ichino.
My lord,
Is
kindly
open
permit
under-
me to have
Let me go through this. Release and annual shares, scripts, and other investment instruments, as well as there are from his custody under advocate of compensation. Here in terms of report on function. Yes. Who is for the defendant?
I'm for the defendant number 2, my lord.
Other defendant number 1?
One, I cannot see the learned advocate for the defendant number 1. She was appearing on the last day. She was here a few minutes back. She was here a few minutes back.
Both were represented, no?
Both were represented, yes, on the last occasion.
Sanjukta Ray.
Sanjukta Ray was there.
It is with registrar original site.
With the
The
registrar.
report says that the scripts have been handed over by the commissioner to registrar original site. Now it is to be distributed.
No, my lord, it need not be distributed. It cannot be distributed. There is a partition. There is a partition. There was a part. Justice Basu Chaudhary was appointed as a partition committee as my lord was then as a practicing advocate. There was a report in regard to how the share script will be divided among the brothers. The report is already there. I've annexed the report with my application. We will be one of the advocate for the plaintiff will be taking custody of the share scripts and will be dividing them amongst the parties. As per the report of the partition commission, a person will be appointed by us amicably. I believe that we all have the consent. There will be a person amicably appointed who will be liquidating the shares and transferring it to the respective demat account by converting it into an electronic form. These are paper shares, my lord. This has to be converted into electronic form, and in the mode how it will be distributed is already there in the report by the partition commission. In that report, in that mode, my lord, we will be taking it. Will take custody of the shares. For the timing, I'll be taking custody of the share. The learned advocate on record for the plaintiff will be taking custody of the shares. A person, he will be appointing a person, my lord, upon consultation with all the parties. A person will be appointed who is an expert in this field. Well, he will move before the SEBI or the exchange board, whoever is there. He will moving it before them to convert it into.
Who is he?
A person who knows, a person may also be appointed by this court, a commissioner may also be appointed in this court.
When you are saying with the consent of the other parties, a name, you propose a name?
We haven't come up with a name. We'll be coming up with an agreement amongst ourselves. We'll be taking the custody of the shares from the court.
The register original site was supposed to furnish a detailed DHC.
You want to go through the report?
Lordship,
The other matters, there was removal properties too, my lord, that has been settled. We have taken custody of, we have taken possession of the properties, my lord, we have demarcated it themselves, we have mutated our names, all things are gone. Only in regard to the movable assets, we'll be taking custody of the paper shares. We'll be appointing a person amicably upon an agreement. That person will convert it into electronic form and thereafter transfer to us. We'll make an application for transfer to our respective accounts.
Yes.
I've gone through the report, Lordship. The register original side, he says that it is in his custody. So that is not an issue. Now, how the shares will be distributed amongst the stakeholders as per the percentage of each stakeholder.
I'll just indicate how is it demarcated. Kindly takes me J8. Kindly comes to page 111. Just have a glance at in respect of one share. How is it demarcated? The schedule, annexure A1 schedule 111, page number.
Yes.
This is the decree, the property, the list of properties. Kindly have a look at 60 preferential shares of Indo-Burma Petroleum, IBP. It kindly comes to page 134 now. This is the commissioner's report, which we have agreed on. One, three, four.
Yes.
Kindly have a look at the
Plaintiff, one, two.
Indo-Burma Petroleum. Plaintiff will take 20 shares. Defendant number 1 will have 20 shares. Defendant number 2 will have 20 shares. But this has been agreed by all the parties. The signatures are appearing in at the bottom. But who will get how many shares? Well, this is already decided. The only thing is that we need to appoint a person who will be taking. I will be taking the custody of the shares. The advocate on record, who is there, Mr. Proceeding only will be taking custody of the shares. He will appoint a person upon consultation with all the parties. He will be acting as a mediator rather. He'll take consent of all the parties. They will come into an agreement. He'll appoint a person who will convert these paper shares into electronic form. And thereafter, as per the demarcation, they will be sending it to their respective demat accounts.
Come up with a name. The person you say that he's an expert in doing this transfer in electronic form. Come up with a name which is acceptable to all the parties.
Person can be also appointed. We have no trouble with that. A person can also be appointed by the school. Any person.
Lordship, only one thing is that the custody that will be taken, let it be the joint custody of the plaintiffs and
three person cannot hold on to the shares.
Whatever, there
somebody has to be there. Name may be suggested. My lord, give a name. We appoint him.
Is there any receiver in this case?
Receiver was Mr. My lord, Justice Raja Chaudhary was the receiver. He has relieved himself from the matter.
After that,
at present there is no receiver. A special officer may kindly be appointed. That will also serve the purpose. At present, the brothers are coordinated relationship with
Ashun. Here is the report of learned registrar original side. Dated 25th September 2024. আচ্ছা, ওটার উপরে একটা দিন। This is an application seeking direction upon the learned registrar original site to release and hand over the shares, scripts and other investment instruments as well as accretions thereof from his custody to the learned advocate on record for the plaintiff, who shall distribute the same among the parties in terms of the report of learned commissioner of partition. It is the report of learned registrar original site dated 25th September 2024. It is found from the aforesaid report that the relevant share scripts are lying in the safe custody of the registrar original site. Flag D. চেক করতে হবে। Sixty take farmer. Farmer lorry 433. Hukum Chand 100. Anglo India 58. Aura Mix 100. Boj 48. 50. Metal Box 100. Straw Products. Color police 10 kilo. Color it's lot. It's 16 ষোলো নয় check করা আর কারি T465 So, okay. ये कोথায় গো? অঞ্জনবাবু কোথায়? দাঁড়ান না, you check the list annexed to the report. There are some discrepancies with regard to what has been listed by the commissioner and the report at page D. There is a table, page D, you find out. I just indicate number 9. Balarpur Industries Limited.
Page
First, take your GA application, page 135. 9.
Farmer lorry.
Balarpur, have you got it?
Ballarpur Industries.
Ballarpur. How many are there in the registrars?
5.
And 135, how many are there? Ten. Now, alkali chemicals. We should take from. Go through the report. Asunto? No, you go through the report.
5 shares. Here it is only showing 12.
Here is the report, hello? Learned Register original site has annexed the
There are two entries,
table,
11 and 12.
being annexure D, containing the shares and scripts. ये অঞ্জনবাবু এটা কিন্তু এটা কি এখান থেকে সাবমিট
চলো তুমি আর আমি যাবো, আরেকটা ফিল হবে, জিজ্ঞেস করো তোমার মক্কেলকে, জিজ্ঞেস করো দেবে
circulate the report amongst the parties. Is this matter 2 weeks after the vacation?
In the meantime, may I just take an inspection of the shares that
I
is
have asked the registrar to circulate the report amongst the parties.
Yes,
Get the table as well as the report. You tally with the commissioner's report and come back after vacation.
there. In the meantime, what I suggest, there's a long holiday period in the meantime. We'll post it after 2 weeks after vacation. In the meantime, we'll be having a look at the shares. There must be some clerical errors or typographical errors maybe. We'll just physically verify what is there in with the registrar original site.
Not now. You just verify from the report. Registrar has sought the liberty from this court to produce all these share scripts in court. So that is right now it is not required. First you get the report,
Yes,
tally
certainly,
the
certainly.
commissioner's report along with the GA application. What is there?
What is the discrepancy? I'll point out. I'll bring out short notes on. Lordship's leave.
After 2 weeks after vacation.
Leave.
Any-
We have to appoint commissioners again. We'll have like Section 9 applications. We need commissioners like Section 9 application. We'll go and take custody.
Why?
Section 9 Arbitration Act.
Oh, CT code.
Grateful.
Item number 14.
14, 15, and 16.
That matter.
GA 1, 2, and 3.
One was allowed by this court. Thereafter, the order was recalled. That matter.
But by 10 September order, my lord, your lordships are pleased to recall the GA 1, my lord. And the PLA was dismissed for default the month of January 2023. Restoration of that was filed as GA 3, my lord, and GA 2 is the Section 5 application for condonation of delay for 589 days. My lord, at the time of GA 1 was disposed of, at the time of passing order, my lord, inadvertently, it was not informed to the lord, your lordships that matter was dismissed for default.
This order has been recalled.
That order was recalled. My lord, a composite order may be passed, my lord, so that matter may be restored and amended.
And GA2 এর অর্ডারটা নাকি GA1 এর অর্ডার?
GA 1 এর অর্ডারটা এতে
Which will be the first GA to take up? Which will be the first one? First application? Condonation of delay?
condonation of delay.
Which is that application?
GA 2, my lord, it sends second matter number 15.
Three is the restoration application.
3 is the restoration.
What is the reason for delay?
My lord, delay is the main reasons for delay is the illness of the beneficiary. The only surviving beneficiary who is the applicant before your lordship is seriously ill, and he stays at America. My lord, he underwent the series of treatment, bypass surgery, etc. My lord. For that, my lord, the
In which paragraph you have written?
my lord, Lord, if your lordship kindly takes up the GA 2, my lord, para 2 is the explanation of 589 days delay, and thereafter para 3, my lord, the reasons for appointing advocate at appellated stage. When the matter was dismissed for default, there was no advocate to look up. The propounder was dead. Thereafter, the problem arises. And the only beneficiary, my lord, is not in a position to control the litigations.
Now, who is Pradut Kanti Guho?
Is the only beneficiary under the will. He is the applicant before your lordship. Kanti Guho is the only alive beneficiary. In para 5 of the GA 2, my lord, we have stated para 5 of the GA 2. At the time of filing GA 1, my lord, neither the petitioner nor the newly appointed advocate was aware of the dismissal of the probate. And consequently, the fact of dismissal was unintentionally omitted from the conversion application due to inadvertence. That has been stated in paragraph 5 of the GA 2.
GA 3.
GA 2, my lord. The same thing has been condonation of delay, my lord. GA 2 in paragraph 5, my lord, things has been stated on.
Okay. This submission has been recorded on the last occasion and the order has already been recalled.
Well, only the word inadvertence, my lord, that has not been gone. Said absolutely unintentional mistake. It's an omission on our part. There may be restored and order for amendment may be passed.
Ashok. GA 2 and 3 একটা order করবে 2 and 3. These applications being GA 2 of 2024 and GA 3 of 2024 has been filed for condonation of delay and for restoration of the probate petition being PLA 338 of 2019 upon such condonation of delay. Mr. Sanjeev Da, learned advocate for the petitioner, submits that the petitioner is the only beneficiary under the will.
Alive beneficiary surviving. There are
Surviving beneficiary under the will. The petitioner is a non-resident Indian NRI residing in Glastonbury, Connecticut, USA. And as such, he was not aware. The probate proceedings was being pursued by Devashish Chatterjee, was the executor. Was pursued by Mr. Devashish Chatterjee, who passed away on 14th October 2020. The petitioner was unaware of the proceedings. The petition for probate was dismissed for default on 18 January 2023. On September 6, 2022, doctors performed a complex 3 bypass surgery to restore proper blood flow to his heart. Due to such critical condition, the petitioner Pradyut Kanti Guho could not take appropriate steps for recalling order of dismissal and for restoration of the probate petition. He seeks for condonation of delay and restoration of the petition. Two master summons to these, two master summons. 2 or 3 master summons to Dintu. 2.
Amendmented master.
Yes, it seeks for condonation of delay of 589 days in filing the restoration application. Upon going through the amendments made in the application and the submissions advanced, this court finds that sufficient reason has been shown to condone the delay. Accordingly, delay of 589 days in preferring the restoration application stands condoned. The application being G2 of 2024 stands disposed of. In G3 of 2024, it is contended that the newly appointed advocate was not aware of the dismissal of the probate application. The contention as made in the application is accepted. The application probate petition being PLA 3 of 338 of 2019 is restored to its original final number. GA 3 of 2024 stands disposed of. GA 1. This is an application for recording death of executor, namely Devashish Chatterjee, and converting the application for grant of probate to an application for grant of letters of administration. This is an application for recording death of the executor, namely Devashish Chatterjee, and converting the application for petition for grant of probate to a petition for grant of letters of administration. Mr. The learned advocate appearing for the applicant submits that during the pendency of the probate proceedings, the executor, namely Devashish Chatterjee, expired on 14th October 2020. He indicates that the applicant is the only surviving beneficiary under the will. He seeks for conversion of the petition for grant of probate to one for grant of letters of administration. You have annexed the death certificate?
Of Devashish Chatterjee.
Yes. It is found from the death certificate appended to the application that executor, namely Devashish Chatterjee, expired on 14th October 2020. As per the
page 23 of the GA1
will of the testator, the applicant Produt Kumar Guho,
Produt
Kanti Guho, is a beneficiary under the will.
only surviving beneficiary.
That means, in view of the aforesaid, let there be an order in terms of prayer A to D of the master summons. carry out. Department is next and department directed to carry out the amendments within 3 weeks from date of reopening of the court after puja vacation. GA1 of 2024 stands disposed of. আমি ওপরটা দেখে নেবেন GA3 আর GA2 গুলো ডিসপোজ করেছে ডিসপোজ কোনটা বলুন? হ্যাঁ, এটা মাস্টার সামান্স তো GA1 টা মাস্টার সামান্স, ওটা কি নোটিশ অফ মেসন?
GA2 3 এর নোটিশ
তাই করে দেবেন, দেখে নিন।
grateful to you.
Item number 17.
Your Lordship, in this matter, GA3 is basically a continuation of GA2. Your Lordship will see page 6, which the order in GA2 is given. There was some confusion with regard to a locker and some of the other items in the affidavit of assets.
Page number
6. Your Lordship, that's an order of 14th March 2024.
Prayer B.
Yes, prayer B.
Done in this.
Of GA2. Your Lordship has a copy of GA2 with.
No.
Your Lordship, I can just give a copy of the GA2. That's GA2.
Prayer B. Need to amend modification.
Leave to amend and make modification to the affidavit.
Details obtained through inventory. Okay.
Your Lordship, now what transpired in the course of the proceedings, the bank came and intimated that the beneficiary of the will was also a nominee. So there was no requirement to get an order from the court with regard to the locker. So the locker and certain other details were slightly, there were numbering mistakes, and by this time also the interest amounts had increased in many of the fixed deposits. So those had to be corrected in the that was by the order. So this is basically that application. Since after this order, to formally make those changes, amend, I have to take out this application for amendment of the affidavit of assets. This is only for that, with respect to that. What had already been ordered by this court, I had to formally do this. So allowing only for the amendment to be taken out. That's all.
Correction audited this and when you modified this.
Your Lordship sees my affidavit in support of the master summons and goes to paragraph 4.
Paragraph
4.
But then what was allowed in GA2?
Your Lordship, GA2 B, prayer B, that is leave to amend and or make modification to the affidavit. Inventory of the safe deposit locker, as well as the information regarding mutual funds and post office box savings. This is all that is there, Your Lordship. Those amendments are being carried out, and that is all.
No amendment has been carried out.
Yes, Your Lordship. The amendments are being carried out. Your Lordship will have a look. Your Lordship will come to page 65.
Yes.
There, Your Lordship will see the red line corrections are there from page 66 onwards. The corrections have been made. Your Lordship, this is a non-contentious cause, so there is
No, any amendment has been carried out in terms of order passed in GA2 of 2024.
part of it, yes. Your Lordship, mutual funds, if your Lordship sees 66.
Now,
Mutual
what
fund
is
deposit with
then what is
SBI.
prayed in this application?
Your Lordship, to allow all the amendments which have been.
Huh?
Your Lordship will come to prayer A, an order allowing proposed amendments as indicated in Annexure X. That is the one which I was showing your Lordship, the corrected one. Your Lordship, may I just indicate what happens if I'm amending the affidavit of assets, the day I'm again re-signing the affidavit of assets, the valuation on that date has to be given. Once the order has been made to amend certain aspects, so I have to give a correct valuation of all the details on that date.
Okay.
So that is why the other ones also had to be corrected, because savings accounts, all the accounts in which the interest portion, it has gone up. Something has been, and highest court fee has also been paid. So there is no infirmity with regard to anything.
By now, the interest has also piled up.
Interest?
Interest has piled up.
With
You
regard
have
to?
filed the application on 10th September 2024.
Yes, Your Lordship, it is only on that date. On that date, what is there, that has to be there.
Wait.
I have given the valuation on 10th September. That is all that is required, Your Lordship. Your Lordship, now after this amendment is allowed, the next stage is there has to be an advertisement which has to be carried out. Because I am the sole legal heir, I am the only son of the deceased.
Come to page 3 of your application. This list has been incorporated in the affidavit of assets.
Yes, Your Lordship.
Okay. So what is the ground for filing the subsequent amendment application? In which paragraph you have stated that there is a change in the valuation of the.
Your Lordship, that's why I indicated GA2. The GA2 order was made because of two things. With regard to the lockers, because we needed to, what happens, Your Lordship, is if there is a locker with contents of which is not known, then the officer is appointed by this court who will go to the bank, break the locker and make an inventory. We had made an application for that. Then the bank was asked to come. The bank came and said that there is already a nominee who is the beneficiary himself. So there is no requirement to do all that exercise. So we had to take out the locker which was mentioned in the earlier affidavit of assets, the original affidavit of assets. One, and the mutual funds, we were unaware of at that point of time. We had got to know what the mutual funds and post box office numbers. There was a mistake in the numbers. 3 had become 7 or something, vice versa had happened. Those had to be corrected. That was prayer B in GA2. So that was allowed. All these corrections were allowed. That is why the first this amendment is required. So when we were allowed to do that amendment, what happens is what we best know on that day with regard to the other heads also has to be changed and shown. That is why all the ones have been, and the endeavor has been to make changes in all and showcase it before the court. And the purpose of affidavit of assets, other than if it is a contentious cause, it's a different issue. Other than that is whether it is over 26 lakhs of valuation, then 50,000 rupees court fee has to be paid. Your Lordship, we have already paid the court fees.
Ashwin.
Your Lordship, only one thing, there has to be a now after this, if this is allowed, there has to be an order for advertisements. By way of special citation.
This you have not prayed.
Your Lordship, that is in course, Your Lordship. That's in course, it happens in course. I don't have to pray for in the amendment application.
কি দরকার আছে এখানে?
And because your Lordship will see, your Lordship, if your Lordship sees the last order in page 7, this order has already been given also.
Then carry out that. Carry out that order.
No, your Lordship, after the amendment is allowed, as per the order, thereafter, your Lordship, this same thing has to be reiterated. If your Lordship just has a look at page 7, your Lordship has page 7. That's the order. Second page of the order of 14th March. And the council has further prayed for correction of the order dated and accordingly modified to the extent the prayer for issuance of special citation if we allowed and further paper publication of citation we also allow.
Where is the 4th March order?
The 4th March order I will keep the order, then you'll have to pass that order. The learned counsel for the petitioner submitted that in spite of direction, this was with regard to the bank to come in front. By order so and so, the bank was asked to apply this code on certain query. It appears that though the said order has been communicated, no communication is received.
A PLA application নিয়ে আসো with the PLA application কালকে রাখুন take this PLA টা নিয়ে আসুন অ্যামেন্ডমেন্টটা হয়েছে ওখানে কি প্রেয়ারটা আছে দেখি সব তো এরকম হবে না কি মডিফিকেশন কাম টুমরো PLA এর পেপারসটা আনিয়ে নিন
Item number 18, examination of judgment letter.
I appear on behalf of the
I appear on behalf of
judgment
the
letter.
degree holder, Your
My
Lordship.
lord, on the last occasion, if your lordship takes the order,
Lord, I propose to intervene in these proceedings. My only predicament is, my lord, that my application is, my lord, not ready because we've just learnt about these proceedings. My lord, this proceeding, my lord, is really a fraud being played upon the court. My lord, I will tell your lordship, my lord, just, my lord, a few minutes. My lord, the plaintiff who holds a decree, he is the mastermind of a Ponzi scam where 700 crores have been swindled. This gentleman was in jail for 3 years. And, my lord, the provisions of the 2013 Depositors Act of West Bengal have been applied against him. He's been charge sheeted in these matters. Now, my lord, since this act has been applied, finally, my lord, last week, Justice Bakchi's division bench has granted, my lord, the plaintiff the decree holder bail. But, my lord, as condition of the bail, the honorable division bench has directed that under this act, the state authorities are to, my lord, attach the necessary assets and then distribute, my lord, this money for the benefit of the victims of the Ponzi scam. I represent 8 of the victims. The police authorities are in process of, my lord, ascertaining the assets and attaching, because all these assets have been alienated, hidden, my lord, on foreign locations, etc. And, my lord, the process of ascertaining these assets, my lord, is ongoing. Now, my lord, the money which today the decree holder is claiming, my lord, this also is liable to be attached, because under, my lord, the special statute, it provides that not only, my lord, will the person who was the mastermind of the scam, to whom deposits were made, not only will his assets be attached and his properties be taken, but even the persons to whom this person has lent money, like the judgment debtor here, even his properties and assets would be liable to be attached under this scheme, because the money which has gone from the depositors is changing hands, and the authorities are duty bound to reach the money, my lord, as many hands that it may have changed, and to bring that the money, and in the absence of the money, to seize the properties. My lord, these are, my lord, this is the scheme of the act. Now, my lord, we've just learnt about this suit, and my lord, it's an execution proceeding which arises out of a decree in a suit, or, my lord, in some form of a proceeding where, my lord, some debt has been crystallized between the parties. Now here, my lord, under the statute, my lord, the victims of the scam, whom I represent, my lord, are entitled, my lord, to have assets of both the parties attached, my lord, through the investigating agencies, so that these are then liquidated, and then under the act there is a special court who will then frame a mechanism for distribution of money among the victims. This is where, my lord, the case stands. The bail order, my lord, I can place before your lordship. This is, my lord, the order, my lord, granting bail to my friend's client, who after 3 years has come out, but an express condition has been given that he will not interfere with, my lord, the task of attachment, etc. Give me one for myself. Where's the order?
May I just point
Lordship,
out one
may I
thing? I have also received a telephonic conversation from the
Lordship, and see, my lord, the operative part. Similar orders are passed in 16 bail applications, 16 different cases. But these are only 16 people who've been vigilant about their rights. There are hundreds of other depositors who are, my lord, not in the know-how of these persons. 700 crores. Paragraph 11 onwards.
May I also be favored with a copy?
I don't have one.
Now, what is the application you have filed?
There's no application on it.
I've just learned about this proceeding, my lord, in grave urgency, my lord. My only request is my lordship can push this matter over, so that in the meantime, my lord, I can come with my lordship with all.
Where is that scheme of the act?
Well, kindly, my lord, have your lordship will
Now, the decree holder here is accused in that criminal proceedings,
the mastermind, the decree holder.
not the accused.
No, of course, he's an accused. His son is deceased by his daughter, 5 other
Yes,
relatives.
this is section 5.
Section 5, my lord, kindly see to the right of the page, on the bottom of the how the authorities are to attack. So even the judgment debtors' properties are liable to be attached to this, not just the decree holder.
but that I am opposed.
Of course, he knows.
Provided that it is
Then
found
come up with an application. My property. Yes.
such money or Mr. Lakhani, where is that? Which portion of that?
I'll just.
Till the time Mr. Lakhani finds, may I just point out, I have received a phone call from the Enforcement Directorate in asking me to provide the details of this execution proceedings and the money due to the decree holder. But I'm yet to receive. I have requested them to provide it in writing, but over the phone call, it was not possible for me to verify who the identity of the person. till date, I have not received any phone call, but I have also been asked to visit the office of the ED, where I have visited and also provided some information. No, it's not the ED, it's the EOW.
My lord, the economic offences wing, my lord, is now, my lord, in process of, my lord, tracking everything.
Statement attached firstly.
So if your lordship, my lord, sees there,
Judgment debtor is the borrower.
my lord, point one, firstly,
The
yes,
judgment debtor is the borrower.
is the borrower. So borrower comes under C because he is borrowed from the financial establishment, and
And
the
the decree
financial
holder?
is the financial establishment.
Okay.
My lord, in criminal law, my lord, this corporate veil, my lord, is not a big factor. Because ultimately, my lord, the criminal law, my lord, reaches to the actual persons who have committed fraud. Because the company cannot be put in jail, my lord. How can the company be imprisoned?
Yes.
So, my lord, kindly see B also. If they take the corporate veil point, the statute has remedied by point B. So, under this act, both parties before your lordship, my lord, I am liable, my lord, I am rather entitled to attach, my lord, assets of both the parties, the lender and the borrower, because my money is being played with, which forms subject matter of this proceeding. Not just me and, my lord, other depositors who are victims of my lord, hundreds of middle class families have been, my lord, ravaged in this scam. I am for 8 of them.
Okay.
My lord, my only request is for lordship may push this, my lord, after vacation. In the meantime, my lord, we will come out with a, my lord, an application to intervene in these proceedings. My lord, special law will prevail, my lord, over general law. I will argue this point before your lordship. I will try and find a section under the CPC. But even if I cannot, I'll come under 151 and, my lord, take this point because it's a new statute. My lord, these Ponzi scams with the Sharada and Rose Valley in 2013, my lord, the legislature deemed it fit to, my lord, come up with this law. As opposed to the CPC, which is, my lord, since Adam and Eve.
Lordship, I appear on behalf of the decree holder. Lordship, I as a counsel am oblivious to all this. Your Lordship, I am appearing for the first time in this matter. Your Lordship, my instructions were, I have obtained a decree in 2018. Since 2018, my execution is being pending. I here myself am trying to take out money from my learned friend, which your Lordship will kindly see the orders once. Right from November 2023, your Lordship. In fact, your Lordship kindly takes up 29 September 2023, Order of Justice Moshmi Bhattacharya. Your Lordship, wherein a special officer was appointed.
May I just cut short Mr.
Oh,
that is
Your Lordship,
argument.
Your Lordship, let me just place the orders because I want to show the conduct of the judgment.
I am here today. I have been appearing all along. On the last occasion
And
when this
taking
matter was
adjournments.
taken up, I appeared for the judgment letter. We have stated that the sale of that terrace will be completed within. My lord, the
Your Lordship,
purchaser has pointed out that they are willing to purchase the property and execute the deed of conveyance by after the Durga Puja.
Lordship, may I just make this? May I just place the orders? This contention has
leave it
been
upon your
coming from
lordship.
September 2023.
2 more weeks, the
Lordship
judgment
will-
letter has
no,
asked.
Your Lordship, may I just press
I'm
this?
seeking for.
Your Lordship, 29 September 2023, Mr. Naranarayan Ganguly was appointed as special officer to oversee the sale of the property and to file a report on the status and sale of the property. Lordship, 24th of November 2023, the Council for the Judgment Debtor submits that the judgment debtor is in touch with the proposed purchaser of the property, which the judgment debtor seeks to sell for realization of the decretal dues. Council accordingly prays for an adjournment. In November 2023, they again pray for an adjournment on the ground for completing the sale. The same ground that is being taken today. 19th of January 2024, again the Learned Counsel for the Judgment Debtor seeks some time more to complete the process. Similar, yeah, Mr. Lakmani, please wait for your turn. Then please complete. Let me complete. I didn't obstruct when you were arguing. 23rd of February 2024, the Learned Counsel appearing for the judgment debtor seeks further extension of time of 2 weeks for completing the sale of the rights. February 2024. Thereafter, your lordship will see 19th August 2024 before your lordship again the same plea on the second page. Mr. Prantik Gorai, learned advocate for the judgment debtor, submits that steps have been taken for sale of the rooftop. The intending purchaser that showed interest to purchase the same, but the sale could not be concluded as yet. This is in August 2024. Last on September 2024, they again seek for a 4-week extension. So from September 2023, they have coming to the court and taking the same ground
that they want some more time to complete. Now, since Durga Puja is coming, they want to do it after Diwali.
I'll just point out now.
September 2024, they've asked for 4 weeks. And this is not the first time they are coming. It's taken them 1 year. Lordship, the judgment debtor was in the box. Let him be in the box.
May I just point out, but I have only one asset which I can liquidate to satisfy the decretal sum. That's a roof right. But I am in negotiation, or the negotiation is complete. The person is ready to purchase the property after and execute the deed of conveyance after the Durga Puja. If my learned friend opposes, there is a receiver, let him proceed. This is a roof right that is there. The person who is staying in that building only want to purchase a roof right. But if my learned friend opposes to this, the only option that is left to the court is that to appoint a receiver in respect of sale of that. If he wants to do that, I'm okay. I'm open to it. But I have been submitting that if my lord feels that my client has not been proceedings to sell that.
This is a money execution.
Lordship, my only humble prayer is the special officer was already appointed. Let him take steps. Till then, I am entitled to cross-examine the judgment debtor. Let me conclude that. Lordship.
There was a date fixed previously for examination of judgment debtor.
Lordship. In fact, your lordship, it has been appearing under the heading examination of judgment debtor from your lordship's 19th of August 2024.
When it matter appeared on the last occasion, your lordship was of the.
No, ask him to. I'm fixing a date for examination of judgment debtor. Ask him to remain present. Has it started?
Yes, your lordship, it had commenced. It was on my learned friend's submission that he will
last
make.
time when the judgment debtor was examined was way back.
Now, if the matter cannot be settled by sale of that property for satisfaction of the decree, ask him to step in the dock. Let him examine.
Lordship, let him be in the dock next. On the next date, we will take steps. And vis-a-vis the submissions of Mr. Lakhmani, let him come up with an application. Your lordship, personally, I'm not aware of the facts that Mr. Lakhmani has argued today. I'll take instructions. If that be so, we'll submit whatever is required.
Yes.
I'm not opposing
And your lordship,
proceeding. I'm only opposing the decree holder benefiting from this execution by getting.
No, I've understood, but that application should be on board.
Because we have just learnt about this.
Okay. Since after vacation, this matter will come up for examination of judgment debtor. In the meantime, you file an application, let that matter be listed.
So, because we weren't aware of the stage, we were only apprehensive.
Mr.
lordship, just one indulgence. The special officer has already submitted its report. He may be kindly discharged because there is no further.
But if my learned friend doesn't want the special officer to be there, I don't have any objection to it. It's on his prayer the special officer was appointed.
Lordship, he has he's done the survey. He's called on meetings. I think the job of the special officer is done now.
The report has been furnished.
Yes, your lordship, report has been filed.
Consider recording the fact that we have learning about these proceedings have appeared before. If the court makes this kindly positive,
Mr. Chen. So and so learned advocate appearing on behalf of the decree holder at the outset submits that the learned special officer appointed by this court has already submitted his report and he be discharged. In view of such submissions, the special officer, Mr. Narayan Chandra Ganguly, Narayan Ganguly is discharged. Learned advocate for decree holder further submits that since 1 year, adjournments are being taken by the judgment debtor for sale of the property. However, till date, neither the sale has been effected nor the decree has been satisfied. He seeks for fixing a date for examination of the judgment debtor. Mr. Rachit Lakhmani, learned advocate, intervenes in the matter and submits that the decree holder is accused in a criminal proceedings under the provisions of Indian Penal Code as well as West Bengal Protection of Interest of Depositors in Financial Establishment Act 2013 relating to Ponzi scheme. Recently, it has come to the knowledge of the interveners they are the beneficiaries.
Sorry,
Under
Malad?
the scheme, they were the beneficiaries.
They were the beneficiaries under the scheme.
It has come to the knowledge of the beneficiaries who are his clients
Who are now victims of the scheme.
and victims of the scheme that the execution proceedings is being undertaken by the decree holder, namely the accused in the criminal proceedings. As per provisions of Section 5 of the West Bengal Act, the decree holder as well as the judgment debtor, the properties of decree holder as well as the judgment debtors are liable to be attached. He seeks some accommodation to take out an appropriate application. In view of the submissions advanced by the learned advocates, list this matter on examination of judgment debtor. Second week 22nd November.
Lordship,
For examination of judgment debtor.
let there be a direction for the judgment debtor to be present.
Judgment debtor is directed to remain present on the returnable date.
Grateful, Lordship may grant me liberty to find because the department may create some.
Liberty is granted to Mr. Rachit Lakmani,
My advocate on record.
Ms. Pooja Saha,
The advocate on record of Mr. Lakmani.
the advocate on record of Mr. Rachit Lakmani, to file appropriate applications as aforesaid.
I'm so grateful.
Well, I have one prayer, my lord. On the last occasion, I paid for some further remuneration.
What was the remuneration?
Lordship, 70,000 was the remuneration already paid on the first instance.
I spent 7 days time.
70,000.
70,000, Your Lordship. I'll show you the order.
Enough. 22nd. It audit it will record the part of it.
Item number 19.
But I am for the decree holder, my lord.
But I am for the judgment.
Appearing for the examination of the judgment.
This occasion, I had appeared and requested for mediation of the matter. I had also spoken to my learned friend. There are two suits, execution cases, in which the principal amount for one is 15 and the other is 21. Even if the matter is not, they are not agreeable to go for mediation. Even in this court, the matter could be settled. We are ready to pay. We are the co-sharers because our shares have been, our property, entire property development is not being able to take place because of the injunction, Your Lordship. So we are ready to pay the amount, Your Lordship. Some installments may be granted, Your Lordship. 15 lakh.
My lord, let me first.
Is the two.
Let me place the Milord calculations, Milord. There are two execution petitions, Milord.
19.
Milord, in the first one, Milord. Milord, in the first one, Milord, as on date till 30th September 2024, Milord, the due becomes 37,18,074 in execution case number 363 as per the decree put to execution. And in the second, my lord, the amount as on 30th September 2024 stands to, my lord, 23,93,927. Therefore, 24 lakh roughly. And the cumulative value of these two decrees as on date, because it is incurring, my lord,
interest, my lord,
What
every
is
day.
60?
61 lakhs. 61 lakhs plus. My lord, now the Mr. Pandey, Miss Pandey is appearing for some of the co-sharers, but she has as of now no stake in the matter because she is stranger to the entire proceeding, my lord. Now, if you whether it is a matter that how I get the money. If she pays the money, that's fine. Let her pay the entire amount within a period of 2 months, my lord.
Yes.
Then everything will be over, my lord.
From November, the installments could be granted, your lordship, and 5 to 6 installments could be given, your
On
lordship.
the last day, my lord, she told that I am ready with the money, my lord.
Ready
Now
with
again
the
from
money, your
November,
lordship. That's why we were
Lord, it should
requesting the
not-
matter could go for mediation so that some
mediation
amount.
is not, my lord, required, my lord. Amount is crystallized in
the
the decree.
execution, you know, make payment. What mediation will do?
Your
If
lordship,
you are
some
intending to
amount
make
in the
payment, make
interest
payment, or otherwise you will
forgo.
Yes, that is the
Some
only
amount in
thing.
the interest they may forgo. We are ready to pay the entire principal.
Lord,
Some amount
Lord,
with the interest they
Lord,
will
I will
forgo
beseech
because
your lordship that your lordship can appreciate that in India, my lord, litigation doesn't come for free. And my plaintiff has already incurred more than 40 lakhs in the entire process.
Then
Now, my lord, therefore, if they want to pay, my lord, most welcome. Let them pay within, my lord, let them show some bona fide, and apart from saying that we will pay from future, my lord, let them come with some money.
judgment data.
Appearing for the judgment. My lord, my judgment letter is, my lord, judgment letter is in very bad condition, my lord. He do not earn any penny, my lord. He has asked his family members to pay on his behalf, my lord. My lord, he has told me that he will start paying in installment from the November, my lord. My lord, some time may be given to him. If he doesn't pay, my lord, if he
My
doesn't
lord,
so
in
bona
that-
fide, my lord,
in
after
that-
1
in
month,
that event, my lord,
after 1.5.
my lord, in that event, my lord, let them at least pay one installment before the puja vacation, my lord.
You can do that.
At least show some bona fide before coming.
lordship,
And we will give time till December. I am conceding to that. Let them pay within December. But somebody should undertake, my lord, that they will pay.
Make payment. What is the amount?
My lord, the amount is 61 lakh.
Madam, on 9 September, this order was passed. There was a submission from your side that matter may be settled out of court. Now, 9 September, we are in October. You could have very well asked them that you are intending to make payment.
From the developer that we have, because we are all, the co-sharers are all aged people. All of them's age is around 69 and plus.
Anyway, lord, someone is there to make payment on their part as a guardian.
Because that the developer is also watching the proceedings so that he can give the money to us and we can pay the plaintiff, your lordship. So we were praying the matter may be fixed in November. Meantime, we will file an undertaking
that will-
notifications that we will pay in this amount.
They are present today in court.
They've given they've given a wakalatnama to me.
Are they present in person today?
They are not present today. Lordship. On last occasions, few other occasions they were.
Ask them to remain present on 7th. Let them give undertaking before the court, thereafter fix it. Ask them. Ms. Amrita Pandey, learned advocate appearing for other co-sharers, submits that the judgment daters are ready and willing to make payment without prejudice to their rights, and is also ready and willing to give an undertaking to that effect. She seeks some accommodation for making payment. She informs the court that the judgment daters are not present today.
Lord, she is not appearing for the judgment debtors.
For the co-sharers.
For the co-sharers.
Co-sharers are not present today. Judgment dater, Ajay Jaiswal is present.
Yes.
Huh?
He is present, my lord.
Where is he?
Lordship, he is present.
He is ready to pay. He is ready to pay.
My lord, he has asked his family members to pay. My lord, he do not earn anything, my lord.
But the burden
Okay.
is given
Are
to
his family
somebody who is not a party, and thereby it is being dragged. It is, yes, undertaking may be given from
Ask
the
him to come.
co-sharers. From the co-sharers.
Ajay Jaiswal, the judgment dater is present. The co-sharers as well as The judgment debtor is directed to remain present on the returnable date, list this matter on 7th.
Yes,
7th.
anytime, 12টা, 2টো, 1টা,
Second half ago. 2 p.m.
2 p.m.
Take this.
And my lord, undertaking would be given by the co-sharers. My lord, kindly let that be clear also.
All will give undertaking.
Deeply obliged, my lord.
Calculation.
Yes, I am sharing the calculation. Yes, I am sharing the calculation. Deeply obliged.
Next.
Item number 21.
And I am a petitioner in PA number 36.
My lord, I am appearing on behalf of the plaintiffs. And my lord, in GA number 38, my lord, I am the petitioner, my lord.
36.
36 is my application where your lordship, I take an exception to the report filed by the partition commissioner. Your lordship will remember while hearing another application in this matter, my lord, this is a partition suit where my lord will remember one property has now been taken out of the purview of the suit. As far as the remaining 3 are concerned, my lord, the partition commissioner.
Opposition you have filed?
Yes, my lord, it's ready for you. Both the applications are ready for you. My lord, the partition commissioner has now filed his final report. And my lord, by taking out this application, my lord, I have taken an exception to such application. My lord, my learned friend's application is GA 38, by which he largely supports the partition commissioner's report. Now, my lord, on the first thing I must bring to your lordship's notice, my lord, the 3 properties that are now involved include, my lord, the residential property, that's 109 Aurobindo Saroni. And my lord, there are 2 other properties which are largely used commercially. Now, my lord, the first ground of attack, my lord, may I take your lordship very quickly to page 97 of my application, wherefrom it shall appear, my lord, that this so-called final report, my lord, even if it is termed so, my lord, is not really final. It is basically an inconclusive report. My lord, this is one of my grounds of challenge. My lord, the others being that, my lord, the partition commissioner has largely opined that the properties should be sold and the consideration should be distributed amongst the parties. My lord, to which, my lord, I, representing the majority, 75% of the co-sharers, say that no, the property should be retained and it should be divided in metes and bounds. And my lord, OLT money can be exchanged or extra square foot can be given according to the shares. My lord, will first look into page 97 as to why I say that this report is inconclusive. The concluding paragraph itself shows, my lord, that the report is inconclusive. My lord is looking into GA 36.
36.
My lord, then at page 97. My lord, the report is quite a long one. It begins from page 23. My lord, I shall just take your lordship to the last paragraph. My lord, may I
Yes.
place it? My lord, the last paragraph. There are certain issues relating to the receiver, including tax matter for 2015-16, wherein challenge to huge demand has been made by me, which is being proceeded with before the authority. Matter relating to internal division of partition of construction of a partition wall within the frontal portion of premises number 109 Aurobindo Saroni. My lord, may I just pause here? 109 Aurobindo Saroni is my residential house. There is a small, not rather a small, there is a commercial portion to it, but largely it is the residential house where all the co-sharers have a share, including my learned friend. Kolkata being, there's also commercial portion, as I had already indicated, being the commercial portion which has been done, and there is further issue of payment of taxes of properties and huh? Oh, I'm sorry.
Yes.
and the matter of the application intended to be made by me for grant of tenancy in respect of the frontal portion or portions of 109 Aurobindo Sharoni, as the receiver's account is much depleting for meeting huge electricity bills of the premises and certain further issues. I will address all these in due course. My lord, this he says while he submits his final report. So, my lord, my first ground of challenge is this is an inconclusive report. My lord will kindly not look into, consider the same and rather set it aside. My lord, at the same time, my lord will also look into the order by which he was appointed and what was the direction that was upon him. My lord will now kindly look into the affidavit of opposition that has been filed to GA 38. My lord, where I have annexed the order.
G30.
My lord, the order starts at page 20. 30 is opposition.
The 38 opposition. Opposition, yes.
Yes, my lord, will come to page 20. This is an order dated 26th August 2011, where your lordship will find the plaintiffs present as well as the other defendants. My lord, I shall not take your lordship to the entirety. I will take your lordship to parts and portions. We'll kindly come to page 21 first. The paragraph in the middle. The above added defendants reside at 109 Aurobindo Sharoni. So, my lord, this is just to indicate that this is a residential property. Then, my lord will find by consent of the appearing parties, shares of the partition suit are declared as follows. My lord will find plaintiff number 3, my lord, whose heirs are now before your lordship through my learned friend. My lord, they have 1/12th share. My lord, the defendant number 1, that is me. My lord, I have 1/18th share. And my lord, thereafter, the shares of each and every defendant has been given. My lord will then kindly look into page 23. My lord, the second paragraph from the top.
Yes.
The second paragraph. The appearing parties say that there are 4 immovable properties which need to be divided between the parties to the present. Mr. Such and Such is appointed Commissioner of Partition. Since the Commissioner has to undertake the exercise of ascertaining, my lord, may I put some emphasis on this word, ascertaining whether the properties can be divided, and some of the properties may have to be sold if they are impartable, then it is also desirable that he takes charges of all the properties. So, my lord, this was the specific direction with which he was appointed. And my lord, at page 25, your lordship, just to give a wholesome picture of the order, my lord, there was an order of injunction also. At page 25, the second paragraph from the top, that there will be an order of injunction restraining the parties from disposing of or alienating their interest in the joint estate without previous leave. So, my lord, the partition commissioner has been appointed with the direction of ascertaining whether the properties can be divided. Some of the properties may have to be sold if they are impartable. And my lord, that is in the year 2011. Ultimately, he files a report which my lord, will kindly come back to GA 36. As the final report at page 23, Partition Commissioner's final report. And my lord, at paragraph 21, at page 97, the last paragraph, he says there are several other things which I have to do. So, my lord, this is my first challenge. My lord, my second challenge being, he says the property has to be sold. My lord, I say no, the property should not be sold. 75% of us say the properties should not be sold. My lord, there is a valuer who is appointed. The valuer holds meetings, takes out measurements, surveys the properties. Who is approved by the court. My lord, he also gives suggestions how these properties can actually be divided. My lord, those things are not reflected in the report. So, my lord, first, may I take your lordship to the residential property? My lord, will kindly come to page 31 of GA 36. And this is a huge property, I must indicate to you.
Yes.
My lord is looking into page 31. My lord, may I place it? Particulars of the three properties are as follows. Particulars of property 109, Aurobindo, Saroni, Kolkata. My lord, the location is very important. The said property being such and such is located at Aurobindo, Saroni, Kolkata, being a prominent area of Kolkata city. Aurobindo Saroni is one of the oldest roads in Kolkata. This road joins Acharya Prafullo Chandra Roy Road, Upper Circular Road, with Robindra Saroni, Chitpur Road, and it encompasses the neighborhood of Bidhan Saroni, Shambazar, Hatibagan, Hedua, Thontonia, and College Street. Originating at Ultadanga Main Road, it changes to Aurobindo Saroni at Khanna Cinema Crossing. Acharya Prafullo Chandra Roy Road continues further, such and such. So, my lord, this is a very primely located property. Area of the land. Area of the land is 9 kathas, 3 chitaks, and 24 square feet. That is roughly 9.225 kathas. This is the ancestral house property, which is physically occupied by the co-owners, except 3 co-owners, namely plaintiff number 1 having such and such share, plaintiff number 2 having such and such share, and defendant number 15 also having such and such share. Now, my lord, may I pause here for a moment? My lord, my learned friend is today representing plaintiff numbers 3A and B, being the legal heirs of original plaintiff number 3. So, my lord, they are still, actually, they are occupying certain portions of the property. Building area in square feet floor wise, this is important. Sorry.
Yes.
This is a 4-storied building having ground floor, first floor, second, third floor, and a mezzanine floor in between the ground and first, together with roof and also a garage and several common spaces in all the floors and in the ground. In the ground floor of the building towards road side, being in the southern side of the building, there is a commercial space or portion. My lord, as I had indicated, this is an enclosed area or space in the frontal portion of the property, being southern side portion of the ground floor, opening with a main gate in the roadside and another gate at the common passage inside the building, being north-south passage for entry to and exit from the main building. And such enclosed space has an area of 3,734 square feet. My lord will kindly make a note of it. This is a huge portion. The covered area in respect of the main building being the first floor is 5,560 square feet. Similarly, in the second and third floor, respective covered areas also have the same square feet, being 5,560 square feet. The roof area, as discussed, is 164 and the roof RCC area is 506 square feet, apart from open space of roof area. Within the main building, there is also remains mezzanine floor having an area of 760 square feet. In the said roof, there is Thakurgarh, Thakur Dalan, as also open terrace. Garage space is 675 square feet and common area behind car parking is 264, plus a storeroom at the back side having an area of 43 square feet. Southern side portion of the ground floor of such and such premises being in the frontal portion, enclosed portion in the roadside is a commercial portion and it can be utilized by giving lease, etc., which as already stated has an area of 3,734 square feet, which was earlier occupied by Canara Bank on the basis of a registered lease granted to said bank, such and such. Thereafter, my lord, therefore, my lord will find that there is a commercial area and the remaining portion is occupied by all the co-sharers. And my lord, this is a huge property. There are 4-storied building, ground floor only, there is a commercial area. Parties who reside and which portions they do. My lord, I will not take your lordship through the entirety. I will just show. My lord will find towards the middle of the large paragraph towards the bottom. In each of the main portions of 3 floors,
yes,
that is first, second, third, there are 12 rooms, common spaces, kitchens and toilets. And all these 12 rooms in the main portions of the 3 floors, parties or most of them are residing. My lord, then there is also a T portion of the 3 floors, where the majority group of co-owners are residing or using. Following are the description as per the calculation arrived at from the valuer, Dr. Nayan's submission of map or plan of the premises. Now, my lord, this part is important. By referring to majority group here, I refer to all the defendants except the defendant numbers 14 and 15. The minority group of co-owners, being the plaintiffs and defendant numbers 14 and 15, have no access to the said T portions in the 3 floors. So, therefore, your lordship will find who is the minority and who is the majority group described over here. Your Lordship will thereafter straight away come to page 51. But there are calculations in between. '51. Because this part is also important. Special note. The name of such and such in the map plan. And
No, what is the distinction of minority and majority group? Why this term has been used?
My lord, in terms of shares, minority group, my lord, largely do not want to retain the property.
Okay.
And my lord, that is the view that they have expressed time and again before the Partition Commission. My lord, they basically want to sell it and then take the money. Simple. Of course, my lord, not alone, has to be given to us. That is their view. My lord, we want to retain it. This is our ancestral property. My lord, we want to retain it and we shall demonstrate, my lord. The valuer also had suggested that this is possible. It is not that this is not possible, but the Partition Commissioner says, no, it is not possible. And the only reason he says is because there are numerous co-sharers. My lord, and what I find is irony, a strange irony, because my lord, when he was appointed, my lord, that order specified that there are several co-sharers and what are their shares. So my lord, he was always aware that, and the court was also aware that there are numerous shares. Still, the court had said that the Partition Commissioner will ascertain whether this property can be divided. These properties can be divided, and only if it is found that no, it is not divisible, we'll go ahead with sale. But he says the only reason, my lord, I shall show to your lordship that there are numerous co-sharers, it is not possible to divide. And my lord, this is very contrary to the view taken by the value, suggestions given by. My lord, may I come back to the special note? My lord, I indicate why I am placing this portion. My lord, this is to show that this particular defendant was later substituted, and my lord, all his heirs came and joined hands with the defendant. So my lord, 75% group also included this group. Just to give your lordship an entire picture of what actually transpired. My lord, may I place the special? That's at page 51. The name of such and such in the map plan and in the calculation sheets by Dr. Ashok Nayan is the name of the person who was the predecessor in interest of defendant number 17A to D. He was a party to the suit. The said such and such has died on 12th May 2003. Shares of the defendant number 17A to D have been defined in the preliminary decree. My lord, I shall pause here and then take your lordship to the last paragraph. While the matter was being proceeded with for partition of properties being the subject properties herein, including 109 Aurobindo Sharoni, Kolkata, two sections of co-sharers, co-owners have been formed. Initially, defendant numbers 1 to 7 and defendant number 16 branch, who were and represented by such and such advocate, representing, my lord will find on the next page, representing 58.31%. They came in as the majority. At the subsequent stage, the defendant number 17, A to D, represented through such and such advocate, decided to be taking stand that they would support the defendant, the stand of defendant numbers 1 to 7, that is me, and defendant number 16 to 6, A to 16E, particularly with regard to residential of premises number such and such. Other co-sharers, namely plaintiffs 1, 2, my lord, they are also now mentioned separately, 3A, 3B, defendant numbers 14 and 15 came in as other co-owners representing 25% shareholding and referred to as minority groups, were ordinarily opposing the decisions of the majority co-owners with regard to allotment of properties as per shareholdings of the co-owners. Now, my lord, is very important, this part. It has become certain that there being numerous co-owners, division of properties by metes and bounds to each of the co-owners is not possible. My lord, to read further, the minority co-owners represented by their learned advocate such and such and later appointed advocate such and such for defendant 14 basically and substantially expressed their views that they would prefer sale of the property. Initially, the defendant number 17, A to D, represented through such and such, proposed and took the stand that either sale or retaining the property of at or 909 Aurobindo Sharoni, whatever would be the commissioner's report, his clients will accept the same. And such stand was also recorded in the minutes. But thereafter, it was changed. In the minutes of the meeting of Partition Commissioner held on 9th December 2014, the positive stand taken by such and such advocate that premises 109 should be preserved to the parties or some of them by allowing the persons who were occupying the same to be in possession and by payment of OLT money by selling other two properties if necessary, and that his clients would not vacate the said property. And therefore, there was no question of selling the property, though he agreed that division and or partition of properties would not be possible at that stage. My lord will thereafter, my lord, there is extensive recording of what happens. Will kindly come towards the middle on 14th September 2016.
Yes.
On 14th September 2016, same Mr. Such and Such, upon instructions of his clients, expressed that his clients were agreeable to partition of 3 properties on square feet area basis. That is, each property have to be inspected, surveyed to determine the common area, including garage, roof, stairs, etc., and rest areas to divide according to respective groups' share, and that the common areas should be kept common for everyone. So therefore, your lordship will find now the second option also comes in. One is to retail, second is to sale, and third that it can be divided on a square feet area basis. So these are 3 suggestions which are falling from the parties and being noted by the Partition Commission. My lord, thereafter, subsequently, the group of defendant number 17 A to D joined hands with defendants, and all those defendants represented by such and such advocates. Together, they are representing 75% shareholdings, and they expressed that they would not like sale of residential premises number 109 Aurobindo Sharoni, and that they will never leave the premises. On the other hand, the minority co-owners, being, my lord, this should be read as plaintiff, not defendant. Plaintiff numbers 1, 2, 3A and 3B and defendant numbers 14 and 15 had expressed that they will not reside at premises number 109 Aurobindo Sharoni along with the majority shareholders, and expressed the same to the Partition Commissioner through their advocate. So, my lord, minority says that they will not live. They will leave the property, and we say we will not leave, we will live in the property. Now, your lordship will kindly come to page 54. Now, let's the last paragraph at page 54. This part is important because this is a suggestion which had fallen from my learned friends, clients. In this connection, it may not be out of place to mention that in the minutes of the Commissioner Partitioner cum Receiver held on 30th August 2016, Rudradeep Dotto and Ronodip Dotto, both being sons of late Rabindranath Dotto, deceased plaintiff number 3 submitted, 109 Aurobindo Sharoni should be required to be made by square feet basis, so that there may not be any unequal division amongst the parties. The said 2 gentlemen who are the defendant numbers 3A should be plaintiff numbers 3A and 3B had clearly pointed out that they had
Yes.
May I just place that last part once again? The said 2 gentlemen who are the defendant numbers, plaintiff numbers 3A and 3B had clearly pointed out that they had objection regarding user of common spaces in each of the floors at premises number such and user of garage as well as mezzanine floor, bathroom and kitchen. So they had objection to the usage of common area. Now your lordship will kindly come to page 59. My lord, I am placing this part to show that they are in occupation of certain portions of the property. My lord, the last paragraph. Certain statements made by such and such in his letter dated 4th June 2018 are stated hereunder in the advocate's own statements. My lord, I shall not trouble your lordship with the first paragraph. Kindly come to the second paragraph. In the first floor, my clients, represented by Rudradeep and Ronodip Dotto, are enjoying 3 rooms, 1 kitchen and 2 toilets, all in the eastern side of the floor. So, my lord, they are there also in the property. Once again, it is reiterated by the Partition Commission. Your lordship will kindly then come to page 67.
Yes.
My lord will kindly come to second paragraph. My lord, the first paragraph just reiterates that we do not want sale. There have been meetings held by the Partition Commissioner with the parties to the suit and or their advocates, and also with the valuer cum surveyor, namely Dr. Ashok Nayak. Well, this is important. So meetings had been held with him. When I, the Partition Commissioner, tried to find out a solution for division and distribution by way of partition of all the three available properties, namely the house property at 109 Aurobindo Sharoni, commercial property at 139C Vidhan Sharoni, and ceremonial property at 13B Nirodh Bihari Mollik Road. Even after several discussions, I have not been able to find out any solution for division and distribution of any of the three properties by way of partition amongst the co-owners and or co-sharers. So, my lord, the Partition Commissioner says that he has not been able to find out any way by which the properties can be actually divided. My lord, there is more. Then he says, the property at 109 Aurobindo Sharoni, as already stated, is the house property, and partition by metes and bounds of the property amongst the number of co-owners who are too many are not possible. My lord, this appears to be the reason.
"17 has been listed, number of parties.
Yes, my lord, there
This refers
has been an amendment. My lord, several parties have expired. So, my lord, their names have been struck out. My lord, settlements have taken place. My lord, probates have been granted. My lord, ultimately, we are now.
Too many means how many parties are there?
My lord, at that point of time, there were many. Right now, my lord, we have only 3 plaintiffs. Plaintiff number 3 has been substituted. And my lord, defendants, your lordship will find 1 to 8 along with their legal representatives. My lord, this report was filed before these amendments were carried out. My lord, may I come back at page 67? My lord, he says that the house property at such and such, as already stated, is the house property and partition by metes and bounds of the property amongst the number of owners who are too many are not possible. Even when there have been ultimately 2 sections of co-owners, namely majority having 75% co-owners and minority having 25% co-owners, it appears neither the process of metes and bounds nor the process of division of property in specie, nor even by the process of square feet basis, but all the 3 suggestions that came to him, nor by process of co-owners' actual existing occupational basis have been found possible. Then he says, it appears basically the complaint of minority co-owners is with regard to common enjoyment of the property. The minority co-owners object to the common enjoyment in respect of the property at 109 Aurobindo Sharoni, and they also complain that certain portions of common passage are being exclusively enjoyed by the majority group. So, my lord, he says it is not possible to divide. Largely, there are too many co-owners. And secondly, the minority co-owners are saying that there is a difficulty in common enjoyment of the property, especially with regard to common passages, which are being exclusively enjoyed by us.
Yes.
Now, my lord will kindly come to page 69. My lord, where the valuation of the property is stated. And before your lordship looks into this, I must indicate there have been 2 valuations of the property. My lord, carried out in 2 years. My lord, one in 2014 and the second 2018. My lord, when the Canara Bank, which your lordship has found was occupying the frontal portion, they had vacated.
Yes.
My lord, I have disclosed the valuation reports in my affidavits. I am not placing those. My lord, these observations are relevant. Dr. Ashok Nayak vide his letter dated 29 September 2014, sent the first valuation report of 109 Aurobindo Sharoni at rupees 14 crores 42,000. My lord will kindly mark this value. This is 14 crores 42,000 in the year 2014. My lord, then he writes that according to the valuer, it was impossible and impractical to make partition by metes and bounds of the property, as the property was partly tenanted and there were many shareholders, and in fact some of the shares were extremely small. According to the valuer, it was therefore recommended that the property be put up for auction first amongst the co-sharers themselves, and for that purpose a valuation report was to be prepared. According to the valuer, if any of the co-sharers and or group amongst co-sharers becomes willing to buy the property outright, it would be given to him. But if none of the co-sharers and or co-owners was willing to buy the property, then the same would have to be put up for auction in the open market. It was found by him that the property basically is used for residential purpose, though the ground floor was tenanted to Canara Bank and used for commercial purpose. So far, the valuation of the ground floor commercial portion, the valuer found the market value to be rupees 3 crores odd. And so far, the fair market value of the rest of the property, the residential apartment value, as calculated by the revenue of the government of West Bengal, he found the valuation to be around 10 crores odd. Accordingly, the total value of the property as per the valuer at the time of his first valuation was found to be rupees 14 crores 42,000. Now, the next line is important. No objection appears to have been raised by any of the parties with regard to the said valuation. My lord, I pause here for a minute. My lord will kindly for a moment forget the valuation amount or anything and just make a mark of this sentence, my lord, which I say respectfully submit shows that the parties were agreeable to the suggestions coming from the valuer. My lord, this is important. No objection appears to have been raised by any of the parties with regard to the said. My lord, the valuer was discussing with all the parties. My lord, meetings were being held. The next valuation of the property, that is after Canara Bank left the premises, has been done by the same Dr. Nair.
Yes.
The next valuation of the property, that is after Canara Bank left the premises, was done by the same Dr. Nair. As per report by Dr. Nair, towards making next valuation as sent to the Commissioner of Partition, with a valuer's letter dated such and such, the valuer has commented that the property rate in the area has been drastically reduced during the last couple of years due to lower demand. He came to his conclusion that the fair market value of the auction reserve price of the property would be approximately rupees 13 crores odd. For the purpose of sale of the property amongst the parties concerned, that is the co-owners or co-owners on an as-is, where-is basis. And if none of the co-sharer parties are willing to buy the property at such reserve price, the same should be put up for public auction. Such valuation report as regard premises number such and such as prepared by Dr. Ashok Nayan and sent to the Commissioner of Partition with a such and such letter has raised severe controversies as raised by the minority co-sharers, being the plaintiffs and the defendant numbers 14 and 15. So, my lord, in the second round, my lord, there are objections. First round, there was none. So, my lord, this shows at least that the valuer was interacting with the parties, as I have already indicated before. Now, my lord, will kindly come to page 72. The last paragraph. It appears that in 2018, when Dr. Nayan made the second valuation of premises number such and such, he expressed that the property rate in that area has been drastically reduced during the last couple of years due to lower demand. Since the valuation has to be made for the purpose of family partition, he expressed that a rate of rupees 10,000 per square feet for commercial space, 6,500 per square feet for residential space should be considered. And accordingly, Dr. Nayan came to the conclusion that the property value should be rupees 13 crores odd. While Dr. Nayan made the second valuation, he reduced the valuation from that when he made the first valuation, which was around 14 crores. It is fact to be mentioned that while Dr. Nayan made second valuation, there was no tenant. So, my lord, Canara Bank had left. My lord, with that, look into the next page. It appears that Mr. Such and Such, advocate, my lord, who was representing plaintiff numbers 3A and 3B, was not satisfied with the second valuation made by Dr. Nair. It appears that Mr. Such and Such, at his client's instructions, prepared valuation of 109 Aurobindo Sharoni through one P. Bagade, and Mr. Bagade explicitly stated in his valuation that rupees 13 crores odd arrived at by Dr. Nair is too low valuation. According to him, there are certain most important features in the property that have not been considered, but which are very important. And such important features are, my lord, then he lists it down, south facing. The property has a large vacant commercial space facing Aurobindo Sharoni at the ground floor and is a very busy building in locality having famous Hathi Bagan Street. And such vacant space can be let out at much higher rent. My lord, I pause here for a minute. My lord, these are the objections largely given by the plaintiff numbers 3A and 3B. That, my lord, the vacant space must be let out at a higher rent. My lord, this will become important later on, and I'll tell your lordship why. Because, my lord, there were certain observations, rather submissions made on the last occasion that, my lord, we were bringing in tenants and creating third-party rights in the property. My lord, they were agreeable at that point of time to bring in tenants so that higher rent can be taken out of that property. Thereafter, my lord, the property has a big open terrace having two separate staircases, serving it, and also a toilet which can be let out for marriage party, meeting, etc. And thereafter, my lord, he arrived at other valuations. My lord, I shall not trouble your lordship with that. So this part becomes important because, my lord, plaintiff at that point of time had said tenants were required to be brought in. And they did not agree with Dr. Nayan's valuation because according to their valuer, this should have been taken into account. My lord, the last paragraph is again important. Obviously, the said valuation of Mr. Magade was not approved by the majority co-owners. So 75% did not agree to the valuation. Now, my lord, again, there are further discussions. Your lordship will kindly come to page 75.
Yes.
My lord, the last paragraph. In the meeting dated 20th February 2020, proposal came from, my lord, this is my client, being Mr. Alok Kumar Dotto, being defendant number 1, describing that the frontal portion of 109 Aurobindo Sharoni, Kolkata, previously occupied by Canara Bank, can be divided into two areas. While the frontal portion of the subdivided area can be given to IndusInd Bank as per their offer, towards proposal to grant lease as per offer of IndusInd Bank, and the rear or the back portion can certainly be given to another bank, and preferably to a party who would be paying a lump sum for the back portion. It should be for the back portion of the said area of premises. Can be utilized without making any compromise with the private enjoyment of the property by the co-owners who are residing at the premises. So, my lord, I suggest that the frontal commercial portion can also be divided into two parts, and the residential portion can remain to be occupied by the parties without any disturbance. It appeared to the partition commissioner, my lord, it appears to the partitioner commissioner, cum receiver, that the minority shareholders might not have any objection to the said proposal, amongst others, for the reason that they are intending to relinquish their respective rights of possession with regard to the premises in favor of 75% shareholders upon obtaining the OLT money as discussed above. So, my lord, again, they reiterate that this was their intention. The minority shareholders expressed that if the income be increased to a great extent by giving possession of entirety of the frontal portion of premises number such and such to the two banks, or to one bank and to the preferable party on certain conditions, the minority shareholders would not oppose. So, my lord, they were ready and willing that the commercial portion should be commercially exploited.
Yes.
But however, the minority shareholders expressed that the entire thing will be, of course, be depending on the actual proposal to be given. And I, the defendant number 1, Alok Kumar Dotto, agreed that he will immediately make his best efforts to do the needful and to submit his proposal in writing. My lord, I shall take your lordship later on to the pages where, my lord, I have submitted a proposal. Partition commissioner has said, yes, your proposal is fine. Then we can build a partition wall and then rent it out separately. My lord, those are annexed to this. My lord will now come to page 92. My lord, this is now where the partition commissioner concludes. My lord will find at page 92, this is the schedule and the observation or report of the partition commissioner. Your lordship will turn the page and take the last paragraph on the next page. After taking into account all aspects of the matter regarding the above premises number 109, Aurobindo Sharoni, it appears to me the parties are divided. Admittedly, the majority co-owners who are occupying even excess areas have expressed not to vacate the premises, and at the same time they have expressed to pay OLT money and or compensation to the minority co-owners if they leave the premises. And minority co-owners, on the other hand, on such and such date, have clearly expressed their consent to receive the money as OLT and or compensation for their relinquishment of right, title, interest and possession in respect of the said premises. The plaintiffs advocate such and such in various meetings held with the Commissioner of Partition. My lord, the dates are given. On the next page, it is written that in the various letters, he have repeatedly made his submission that all the three properties have to be sold and that there is no other way for distribution of share to all co-owners. That is, division of properties by way of partition are not possible. So, my lord, they will not stay in the property. They will either accept OLT money or compensation, but then they say later on that the property should be sold because division is not possible.
Yes.
Well, then he says, I say that residential accommodation of the parties should not be allowed to be sold in the marsh. That he agrees. There is no possibility of division of such property amongst numerous co-owners by metes and bounds. There is consensus between the minority co-owners represented by their advocates to the effect that they are interested in their OLT money or compensation against relinquishment of right, title, interest and possession of the said property. Though I fully appreciate that further valuation of the property could be directed by me. This is important. I have refrained from making further valuation for the reason inter alia that long delay would occur in the matter, and it is possibly not feasible during present COVID-19 pandemic episode to allow such further exercise for making inspection of the property once again and for allowing the parties to come together for assisting the valuer in arriving at a decision. Moreover, there appears to be no unequivocal consent of both majority and minority for appointment of any other valuer. My lord, thereafter, my lord will kindly turn over the page, the last concluding paragraph. Therefore, subject to the approval of the Honorable High Court, I decide that minority co-owners would be receiving their OLT monies and or compensation in relinquishment of their right, title and possession, and the majority will pay such OLT money, and otherwise the property will be sold by public auction. So, my lord, he just doesn't toe the line of partition by metes and bounds. My lord, may I stop here today? Because, my lord, on the next occasion, I wish to place the suggestions of the valuer, where he says it is possible to divide the property. My lord, he says very well, I shall place your suggestions. My lord, those do not find a reflection over here in the minutes. My lord, the important portions that I have taken your lordship through, my lord, doesn't find any reflection of these kind of suggestions coming from the valuer.
Or Mrs.
Sulognam.
Sulognam Kochi, the advocate for the applicant. Yours is GA 36.
Yes, Your Honor.
36 of 2023. Is this matter on active date? Bolun, Anjan Babu, when? When I fix a date, then you will say that you have problem on such and such date. First, it starts with that nobody has any problem. কবে আসছে দেখুন এক সপ্তাহ পরে ওই ওই যে 14th 12th you are not here. 14th will be.
Not only one, it has just before your lordship rises, but I've been informed that I have not been given any order as of now, that your lordship has been pleased to appoint me for some Shubhava.
It will be uploaded. The order will be uploaded.
Conflicted in that matter because some of the distant relative Malad of there could be some issues Malad if your lordship and we have not yet
You have difficulty. Let me upload the order first. Then I have to take it because the other parties are not here. Then take it in to be mentioned and then
your lordship is not signed. That's why I was.
that is correct. That is correct.
Possibly that.
করবো তাহলে ওদেরকে ইনফর্ম করতে হবে হুম না ওদের বলে দিয়েছে ওরা চলে গেছে না হুম Oh, let the order be uploaded. You have a serious difficulty in doing that. If it is not, then you
Might be conflict because from whatever I've heard over phone, I have not yet because the order is not there. So I do not know, but they have told me it's regarding Shubhavaya. So
Yes.
that is why I.
Okay. Since the order has been passed in the open court, I upload the order. If you have any difficulty, I put it in to be mentioned and change